Committee on State Affairs come to order. Clerk, call the roll.
Chair King,
Here.
Vice Chair Hernandez, Antia, Darby, Davis, Garen, Ian, Hall, McQueen, Metcalf, Phelan, Raymond, Smithy, Thompson, Turner.
We have a quorum. As a reminder, anyone wishing to testify before the committee, please register in the kiosk located in the hallways behind the hearing room. If you require assistance in registering or testifying, please contact the committee staff. As stated on the hearing notice, we will have a time limit of 2 minutes per witness that will be enforced. If somebody says what you were going to say before you say it, ditto is acceptable in this committee as always, and we do take written testimony. As a reminder to the committee and our visitors and witnesses, today under House Rule 4, Section 13, House committees are subject to the same rules of decorum that govern the House proceedings under those rules. The chair is responsible for preserving order and decorum during committee meetings, and the chair may ask the sergeant at arms to assist in preserving order and decorum. Outbursts or vocal displays of support or opposition from visitors in the audience are prohibited, and the chair may order the sergeant at arms to clear the audience if there is a disturbance that disrupts the committee meeting. Signs, placards, and other objects of similar nature are prohibited. Food and drink are prohibited in the hearing room. Members of the committee and witnesses must confine their remarks to the matter being considered. Members will be taking up pending business upon adjournment when we can get the rest of our committee here. Chair lays out House Bill 4211. Chair offers up committee substitute to House Bill 4211 and recognizes Representative Noble to explain the bill.
Thank you, Mr. Chairman. Members, good morning. Thank you for allowing me the opportunity to lay out committee substitute for House Bill 4211. Members, before I begin, I just want to say this clearly. I'm 100% for religious freedom. I'm 100% for personal property rights, and I'm 100% for freedom of association. So I just kind of wanted to lay that groundwork as foundational to this bill from me. This bill is a result of a proposed development in my district. This isn't your typical subdivision or planned community. It's an innovative in design, creative in structure, and completely outside of what we've anticipated in Texas law. You may have heard about it. The development is called Epic City, and then they have other parts that are called Epic Ranches. An individual does not simply buy property in Epic City. Instead, for a significant investment, at least $80,000, a person might qualify to become an investor and therefore might be allowed to have access to purchase a lot. Is it a timeshare? Is it a co-op? Is it a MUD, a PID, an HOA? The answer is it seems to be a little bit of all of those, and technically none of them. What's not clear is whether investors actually own the land or just have access to it to build on it. That's the problem, because when it comes to a person's home, ownership means something under Texas law. House Bill 4211 creates a new chapter in the Property Code, Chapter 223, titled Business Entity Owned Residential Arrangements. It ensures that when a person invests into one of these arrangements, no matter how creatively it's structured, they are still afforded rights under Texas law. This bill has several key points. It confirms that investors have rights of ownership and transfer even if the property is held by a managing business entity. It requires that all disputes be settled and resolved in courts established by Texas or the United States. It prohibits the managing entity from interfering in the transfer of an investor's ownership interest and bans any fees or profit sharing from those transfers. And it applies the Deceptive Trade Practices Act, both the state and federal Fair Housing Acts, to protect individuals from discrimination based on race, color, religion, national origin, sex, familial status, or disability. The committee sub for House Bill 4211 clarifies that the Office of Attorney General, who by law is given authority to investigate violations of deceptive trade practice, has the explicit authority to investigate business entity-owned residential arrangements and seek an order by a judge to address those concerns. A judge's order may pause public funds and benefits regarding construction and development permits issued by state and local government entities until such time as concerns are addressed or resolved. I'm happy to answer any questions and reserve the right to close.
Members, are questions, Ms. Noble? Seeing none? Oh, Mr. McQueenie has one.
Thank you, Mr. Chairman. Thank you, Ms. Noble. Would you be putting this same bill forward if this was a Baptist community?
It's a great question, and I've actually thought about that a lot. I'm a Baptist, for those that don't know, and the answer is yes. I actually served on a grand jury in Collin County years ago, and we actually had two members of my own church that were scammed by another member that came before the grand jury, and it was very uncomfortable. And so no matter what the business arrangement is, we need to have these resolution allowed under law. Also, I don't know if anybody's ever been in a Baptist church, but we can't agree on anything for more than 30 minutes or so. And so we would have a split, and I don't know how that would affect the development. This development includes a mosque, K through 12 schools, a community college, a clinic, and retail and other things. So that will be commonly paid for.
Yeah, thank
in
you.
this
I
development.
just think it's important to talk about this as a, property
It's a
owner.
general- it's a general property
owner right
owner's-
situation. So I appreciate it.
Thank you. Thank you for that question.
Members, other questions, Ms. Noble? Seeing none, we will bring you back shortly.
Thank you.
All right. Is there anyone wishes to testify on, for, or against House Bill 4211? Seeing none, Chair recognizes Ms. Noble to close.
I respectfully request passage.
Thank you very much. All right. The committee substitutes withdrawn. If there's no objection, House Bill 4211 be left pending. Is there objection? Chair hears none. House Bill 4211 is left pending. Darby. Okay. Chair lays out House Bill 4536. Recognizes Chairman Darby to explain the bill.
Thank you, Mr. Chairman. Members, this bill seeks to improve procedural fairness and transparency in how wage complaints are handled on public works projects here in Texas. Currently, Chapter 2258 of the Government Code governs the enforcement of prevailing wage laws and publicly funded construction projects. Under existing law, when a public body receives a wage complaint, it may initiate enforcement actions, including the withholding of payments, before notifying the contractor or subcontractor involved. This bill makes two key reforms. First, the bill requires public bodies to provide written notice to the contractor or subcontractor as soon as practical after receiving a complaint. This ensures employers are made aware of the complaints early in the process and have the opportunity to respond before funds are withheld or formal proceedings are initiated. Second, the bill updates the timeline for public entities to make a determination on the complaint. Instead of counting from the day the complaint is received, the 31-day window will now begin once the contractor or subcontractor has been notified. Members, this bill is about ensuring a balanced and transparent process, one that gives all parties a fair opportunity to be heard without compromising the enforcement of labor protections. With that, I'll be happy to answer any questions the committee may have.
All right, members, are questions for Representative Darby? Seeing none, you have a couple witnesses. We'll bring you back shortly.
Okay.
Chair calls Spike Cutler. Record shows you're Spike Cutler. You're testifying on behalf of yourself, and you're for the bill. Is that correct?
That is
Please
correct.
proceed. You have 2 minutes.
Chairman King, appreciate your time, members of the committee. Thank you very much. I am Spike Cutler. I'm a construction lawyer, 32 years. This is what I do. The reason that this bill is so beneficial, of course, first of all, Texas, we have wage scales for all public projects to ensure that people are paid fairly and equitably. It's a settled law and it works well. The problem is, if there is a dispute, and it could be a dispute over whether somebody's being paid the right wage, whether they're being paid the defined rate, or whether they're being classified as the right kind of labor, they can make this complaint to the public agency, and the public agency has to make a finding. Sometimes employers hear about it, but there's no requirement that they hear about it. The purpose of this bill is simply to make sure that the responsible employer is notified, so they have the opportunity to, number one, educate the public agency about the classifications of the labor, and number two, if there's a problem, to fix it before they get into paying lawyers. Paying lawyers is a noble and honorable undertaking, but nobody gets out of bed in the morning and says, this is the day I want to pay lawyers more money. So the goal on this thing is to help make sure there's clarity, to make sure that there's information shared, and to resolve problems small problems before they become big ones. Nobody loses any rights under this. All we do is gain information. I would urge passage of this, and I'm happy to take any questions you may have, and thank you for your time.
Thank you, Mr. Cutler. Members, questions of this witness? Seeing none, thank you for being here.
Thank you again very
Chair
much.
calls Mark Emmons. Record shows you're Mark Emmons. You're testifying on behalf of Intrepid Electric and yourself, and you're for the bill. Is that correct?
Yes, sir.
Please proceed.
Okay, so we have experienced in the past several years that the effects of not knowing in advance about the complaints. And we have, we've been notified after a decision has been made that we were in violation, which could have been fixed if we would have known in advance. And then at that point, you have to hire an attorney. As you all know, attorneys are expensive. And this could have been fixed before. We've had people that complain about it to me, and I was able to, okay, yeah, you're right, I'll pay you. Or explain to them, no, the specs say that this is the price, and that's what you're getting paid. And there was no attorney fees involved. But we've also had others that that we find out, 45 days or later when the county's made a decision that we were wrong, and then the next thing we know, we hear from an attorney, and I'm not going to visit with an attorney because I don't know, so I have to call Mr. Cutler. So I urge passage of this just for fairness for the contractors to try to repair any damage before it gets expensive.
Okay. Members, are questions of Mr. Emmons? Seeing none, thank you for being here.
Thank you.
Is there anyone else wish to testify on, for, or against House Bill 4536? Seeing none, the chair recognizes Representative Darby to close on this bill.
Thank you, Mr. Chairman, members, I close.
If there's no objection, House Bill 4536 be left pending. Is there objection? Chair hears none. House Bill 4536 left pending. Paul. Chair lays out House Bill 1907, recognizes Representative Paul to explain the bill.
Thank you, Mr. Chairman, members. It's good to be with you here today to speak about this bill. Texas spends about $4.7 billion each year on information technology, goods, and services across state agencies and higher education. Every dollar and every byte that travels through our network should be secure. Yet right now, state law does not prevent Chinese-owned vendors from supplying the very routers, cameras, and software that sit inside our courthouses, schools, and 9/11 centers. This is a glaring risk. The threat is real and documented. In 2005, the Salt Typhoon cyber espionage campaign tied to Beijing breached multiple U.S. telecom providers, prompting the FCC to call for stronger defenses. The FCC has already banned new authorizations for Huawei, SZTE, Hikvision, and other Chinese equipment because of unacceptable national security risk. Governor Abbott likewise banned TikTok from other Chinese apps from all state devices. Current Texas law only covers the critical infrastructure contracts, SB 2116 from the 87th Ledge. That leaves a loophole for information and communication technologies, ICT, outside narrowly defined infrastructure. HB 1907 closes those gaps. It bars a Chinese-owned or controlled company, a scrutinized company, from bidding or subcontracting with an ICT used by state or local government, requires written verification for every vendor that no portion of the contract will rely on scrutinized company, imposes stiff penalties, immediate contract termination, a civil penalty of up to twice the contract value, and state jail felony for willful violations. Allows narrower governor-approved exceptions where no alternative exists or the Chinese source competition is truly demerits and poses no security risk. I'm currently working with stakeholders on a committee substitute that will further more narrowly define the scrutinized company, and happy to answer any questions.
Okay, members or questions for Mr. Paul? Seeing none, hang on.
I reserve the right to close.
You're going to get that opportunity. Is there anyone else wish to testify on, for, or against House Bill 1907? Seeing none, Chair recognizes Representative Paul to close.
All right, appreciate y'all's assistance for this, and Mr. Chairman, thanks for hearing this bill, and I close.
Absolutely. If there's no objection, House Bill 1907 be left pending. Is there objection? Chair hears none. House Bill 1907 is left pending. Oh, did I? I never did recognize Keegan. All right. Let the record reflect that Representative Metcalf is with us. Yeah. Do you want? Which one is it? All right. Chair lays out House Bill 2892, recognizes Vice Chair Hernandez to explain her bill.
Good morning. Thank you, Mr. Chairman and members. House Bill 2892 would protect the privacy rights of Texans by prohibiting state agencies from collecting, releasing, or disclosing membership, volunteer, and donor information for nonprofit organizations. The Supreme Court has repeatedly upheld that individuals have a right to privacy with regard to the nonprofit organizations to which they belong and donate. This bill simply codifies this right to privacy into state law. Under HB 2892, state agencies would be prohibited from collecting, releasing, or disclosing membership, volunteer, and donor information for nonprofit organizations unless this information is volunteered by the individual or is otherwise necessary for legal or law enforcement reasons. While some Texans would certainly like their charitable contributions and associations to be public, many others would not, and this bill protects the privacy of those Texans by preventing public agencies from compelling this information. Every American has the fundamental right to support the causes and organizations they believe in without fear of violence, harassment, or intimidation. This bill codifies protections for the individual and ensures that nonprofits will continue to be able to perform their valuable societal function without interference. We are working on some language. I don't believe we have that language before us this morning, but I will bring back a substitute with some agencies that we've been working on too.
Okay. Members or questions for Ms. Hernandez? Seeing none. You do have a witness, so we'll call you back shortly. Chair calls Megan Schmidt. Record shows you're Megan Schmidt. You're testifying on behalf of Philanthropy Roundtable, and you're for the bill, is that correct?
Correct.
Please proceed.
All right. Good morning, Mr. Chairman, members of the committee. My name is Megan Schmidt, and on behalf of Philanthropy Roundtable, I'm testifying in support of House Bill 2892. We appreciate the opportunity to testify today and thank Vice Chair Hernandez for again authoring this important legislation. The freedom of Texans to give and associate anonymously is a key pillar of the state's vibrant civil society. Texas is home to well over 130,000 nonprofit organizations, ranging from foundations to human service organizations to religious organizations and so much more. Nonprofit donors may choose to give privately for a number of reasons, such as religious tradition, modesty, or a wish to avoid threats and/or retaliation. House Bill 2892 keeps these safeguards in place and would strengthen the nonprofit donor privacy laws in the state. This legislation prohibits public agencies from disclosing or releasing personal information about membership, volunteers, and financial or non-financial donors, unless required by law. Donors and volunteers would have peace of mind knowing their personal information wouldn't be publicly disclosed. The right to give and associate privately has been upheld by the Supreme Court multiple times over the years, with the court affirming in the most recent case the robust protection of privacy rights under the U.S. Constitution, underscoring the fundamental importance of the right to freely associate without fear of government intrusion. To date, 20 states have passed a version of this bill, including unanimously out of states such as Colorado and Alabama. Last session, the bill previously passed unanimously out of State Affairs Committee, and recently the Senate version just passed out of committee with no opposition. America has an independent and robust civil society unlike that of any other nation. The vitality of civil society and the long-accepted norm that private giving for philanthropic and civic purposes, and that norm should be protected in all but a very few narrow circumstances. Philanthropy Roundtable encourages the committee to advance House Bill 2892. Thank you, Mr. Chairman, and happy to answer any questions the committee may have.
Thank you for your testimony. Members, or questions of this witness? Seeing none, thank you again for being
Thank
here.
you.
All right. Is there anyone else which to testify on, for, or against House Bill 2892? Seeing none, Chair recognizes Vice Chair Hernandez to close on the bill.
Thank you, Mr. Chairman. I close.
If there's no objection, House Bill 2892 will be left pending. Is there objection? Chair hears none. House Bill 2892 is left pending. Mrs. Winger. That's it. All right. Chair lays out House Bill 5182. Recognize Representative Zwiener to explain the bill.
Thank you, Chairman King, Vice Chair Hernandez, and members of the State Affairs Committee for the opportunity to lay out House Bill 5182 today. This is legislation that's designed to make sure that our ethics laws, as they impact those of us who hold office, are actually enforced and have a little bit of teeth. This bill does a few different things. Most importantly, it requires any candidate elected or appointed to public office to have paid off their civil penalties or fines owed to the Texas Ethics Commission prior to the date of the first day of the filing deadline in order to ensure a place on the ballot or before appointment. Members, I'll also be laying out an HJR because of the way our eligibility requirements work for elected offices. We need to both deal with the offices where our eligibility requirements are set in statute and also our offices where they're set in the Constitution. So this bill deals with the eligibility requirements for offices set in statute, which includes our non-constitutional offices. The second thing this bill does is raise some of our penalties from $500 to $1,000 to try and, again, give the Texas Ethics Commission more teeth to enforce those. And then the third and perhaps most important thing this bill does is it gives Texas Ethics Commission the ability to go out and directly hire outside counsel to pursue fines. Right now, Texas Ethics Commission has to wait for approval from the Attorney General's office, and this allows them to go directly to seeking to pursue those fines. I think this is critical for us to make sure the public has confidence in us as a state body that we are following our own ethics rules. According to the TEC's 2023 self-evaluation report between 2018 and 2022, the value of Texas Ethics Commission's unpaid violations totaled $1.4 million. So if we have an agency that is charged with enforcement, they have to have some teeth in order to actually make those violations meaningful or make their enforcement mechanisms meaningful. So by amending the current statute, HB 5182 would allow the Texas Ethics Commission to be self-sufficient in enforcing reporting violations to the benefit of stronger accountability and integrity standards for public servants. Members, I'm happy to answer any questions you may have, and I respectfully request my right to close.
Thank you. Members, or questions of Representative Swinger? Seeing none, we will bring you back shortly. Chair calls Emily French. Record shows you're Emily French. You're testifying on behalf of Common Cause Texas, and you're for the bill. Is that correct?
Yes, sir.
Please proceed.
We support this bill. In 1989, an East Texas chicken plant owner named Bo Pilgrim walked onto the floor of the Texas Senate and gave out $10,000 checks to 9 senators to kill a bill about workers' compensation. This incident became known as Chickengate, and it was legal at the time, but the outrage that followed led to the founding of the Texas Ethics Commission. This commission is an independent body with investigative power that enforces campaign finance laws, or at least it is supposed to. In reality, whether our ethics laws are enforced or not is up to the Attorney General. Our current AG owed $11,300 in ethics fines until very recently, which he did not enforce against himself. If I didn't pay a parking ticket and I incurred a fine as a penalty, most Texans would find it absurd if I also got to review my fine and have a role in deciding whether any action should be taken to collect that fine, although I personally would probably like that. The Texas Tribune found that the number of politicians, lobbyists, and political action committees that owe fines for breaking state campaign finance laws has exploded in recent years. As of this morning, according to the Texas Ethics Commission website, 746 individuals owed the state for delinquent filings for a total of $3.9 million in unpaid fines as of this morning. The Texas Ethics Commission is an important check against unlimited power. It's one of the ways that the people of Texas are able to hold their officials accountable. By ensuring that fines are paid before someone runs for office again, we can ensure that the representatives of Texas truly represent Texas. We support this bill and ask you to report it favorably. Thank you.
Thank you for that testimony. Members, there are questions of Ms. French? Seeing none, thank you for being here. Chair calls Tony McDonald. Tony McDonald? All right, we're gonna show Tony McDonald was testifying on behalf of self, against the bill, not testifying. Is there anyone else wish to testify on or against House Bill 5182? Oh. Okay, hang on one second. All right, record shows you're Tony McDonald. You're here on behalf of yourself and you're against the bill. Is that correct?
That's correct.
Please proceed.
Okay, ran over here. Tony McDonald, I represent grassroots Texans, a lot of times pro bono. In the last couple of weeks, I'm here
But Mr. McDonald, you're testifying on behalf of yourself. Is that
On behalf
correct?
of
Or would you like
myself.
us to change that registry?
No, sir. I'm here on behalf of myself.
Thank you.
I'm against the bill.
I understand.
My apologies, I ran over here. A couple weeks ago, I got a call from a 71-year-old woman from Houston. She was being investigated by the Ethics Commission because she had put a hand-drawn yard sign in her yard. And somebody who didn't like the issue that she was on filed a complaint against her. The Ethics Commission opened that investigation. Poor woman called me. She was in tears. And I was trying to coach her through it. She was only able to find me because I've been so outspoken against the Ethics Commission. But you have to understand, this is not a body that just regulates you. It regulates 30 million Texans. When people go out and they put a flyer out or they put a sign out, the Ethics Commission regulates them. There's a woman from Houston named Darnella Wilkerson, elderly lady. She chose to disclose $3,400 in political spending. She had hired a police escort and a photographer. She chose to disclose that. She tried to comply, but she wasn't an attorney, so she filled the forms out wrong. When they filed the complaint against her, she didn't have a car to travel to the hearing in Austin. When she didn't arrive, they hit her with a default judgment, and she has now incurred $17,500 in fines by the Ethics Commission. That's the reality, is that all of you on this dais, you have reporting obligations that you have, but you have support staff, campaign staff, who help you figure that stuff out. And
Thank you, Mr. McDonald.
Thank you.
Member, are there questions of Mr. McDonald? See none, thank you for being
Thank you.
here. Now, is there anyone else who wishes to testify on, for, or against House Bill 5182? Seeing none, Chair recognizes Representative Zwiener to close on House Bill 5182.
Thank you so much, Chairman and members. If we are going to have rules, it's important that we have mechanisms to enforce them. If there are no other questions, I close.
Members, or questions, Ms. Zwiener? Seeing none, stay put. If there's no objection, House Bill 5182 will be left pending. Is there objection? Chair hears none. House Bill 5182 is left pending. All right. Chair lays out HJR 2201. Recognizes Representative Zwiener to explain the resolution.
Thank you, Chairman, Vice Chair Hernandez, and members for the opportunity to present HJR 201. Members, this is a related piece of legislation to the bill I just laid out. This allows the same requirements for needing to pay your Ethics Commission fines before you appear on the ballot to be applied to the constitutional offices, such as ours and the other statewide electeds. Happy to answer any questions you may have and respectfully request the right to close.
Members or questions, Ms. Sweener, about a resolution? Seeing none, you have a couple witnesses. We'll call you back shortly. Chair calls Emily French. Record shows you're Emily French. You're here testifying on behalf of Common Cause Texas, and you're for the HJR. Is that correct?
Yes, sir.
Please
And in
proceed.
strict compliance with the chair's mandate, I will say ditto to everything I just said. I believe it should apply to these offices as well.
Thank you
Thanks.
so much, Ms. French. Members of questions of Ms. French, seeing none, thank you for being here. Chair calls Tony McDonald. You don't have to run this time. Record shows you're Tony McDonald. You're here on behalf of yourself, and you're against HJR 201. Is that correct?
That is correct.
Please proceed.
And now that I've caught my breath, I'll just have a few more comments. What I was saying and what I'll say to this constitutional amendment proposal, all of you on this dais outsource your campaign finance reporting to professionals, I would assume. I would be highly surprised if many of you are sitting out late at night and we're filling these forms out yourselves. And the reality is if you are, or even if you outsource it, there's errors, all the time. What I would ask you is, as you work through things that deal with the Ethics Commission or deal with political speech, think about the little guy that's out there. That's what I do, is go out and I do a ton of pro bono work, contingency work where I'm really not going to get paid, but trying to help grassroots people who are trying to figure out how to comply with this stuff. And just like I started off with earlier, you have people who are just citizens, elderly people, who are just trying to be involved in their communities. The 71-year-old woman who drew the sign, she drew that to put in her yard because she was opposing the destruction of the local senior center. I mean, this is absolute fundamental citizen stuff. And yet, we have proposals here that would put ferocious teeth into the Ethics Commission to then go after people like this woman who called me just 2 weeks ago. So I would ask you, as you consider these bills, don't, yes, you're thinking about people who spend a lot of money in politics, but those people hire lawyers like me who, coach them through how to do this stuff. Think about what this is going to mean for the little guy who can't afford a lawyer, who doesn't even know that there are rules that he's tripping over. That woman never considered, when I make a hand-drawn sign and put it in my yard, do I have to call a lawyer and ask what political disclaimer do I have to put on that? And so think about that, because that's who's going to really get hurt through this bill, through this constitutional amendment, if it were to be adopted.
Thank you for your testimony.
Thank you.
Members, are there questions of Mr. McDonald? Seeing none, thank you for being here. Is there anyone else wish to testify on, for, or against HJR 201? Seeing none, Chair recognizes Representative Sweener to close on her HJR.
Thank you, members. Although some of our witnesses may not imagine some of us doing their own Texas Ethics Commission's report late at night, I was that candidate my first race and messed up the website and had late filings. And I paid my fines. And that's the right thing we should do, and that's what this HJR is about. I request your favorable consideration, and I close.
Members, there are questions of Representative Sweener? Seeing none, thank you for being here. If there's no objection, HJR 201 will be left pending. Is there objection? Chair hears none. Chair hears none, and HJR 201 is left pending. Mr. Shaheen? What'd you say? All right. Chair lays out House Bill 5138, recognizes Representative Shaheen to explain the bill.
Thank you, Chairman King, Vice Chair Hernandez, and members. House Bill 5138 restores the authority of the Office of the Attorney General to prosecute election-related crimes. It does this by addressing the main areas of concern brought by the State versus Stevens Court of Criminal Appeals ruling. In State versus Stevens, the Criminal Court of Appeals ruled the Office of the Attorney General cannot prosecute election crimes independent of local prosecutors under the Texas Constitution. From these separate constitutional duties, Stevens reasoned that the Office of the Attorney General and local prosecutors cannot both independently prosecute criminal matters without violating separation of power principles. There can't be an overlap in responsibilities unless a request is made. So House Bill 5138 returns to the Office of the Attorney General's authority to prosecute election offenses by using mandatory language, shall prosecute, and by authorizing Office of the Attorney General to do so after a local prosecutor has failed to initiate prosecution 6 months after receiving a report. HB 5138 allows the Office of the Attorney General to prosecute after giving local prosecutors 6 months to bring their own case. By creating a protected time when only a local prosecutor may bring charges, HB 5138 addresses the court's requirements that there be a separation of the areas of operation for local prosecutors on one hand and the Office of the Attorney General on the other. This provision satisfies the Stevens requirement that there be no overlap between local prosecutors and the Office of the Attorney General. With that, Mr. Chairman, I'm happy to answer any questions and reserve the right to close.
Ms. Thompson has a question.
Representative Shaheen, are you carrying this bill for the Attorney General?
I've been in discussions with them, yes, ma'am.
Are you carrying this bill for the Attorney General?
Yes, ma'am, I'm in
Thank you.
discussions with the Attorney General's office.
Mr. Turner.
Thank you, Mr. Chairman. Representative Shaheen, doesn't this require, if this is what you want to do, a constitutional amendment? Because, I mean, don't you basically have to change the Constitution in order to give the Attorney General this power?
No, by changing the wording in the bill that says shall prosecute, there's no longer a conflict between the separation of powers. Wherein before, the legislation that you're referring to said may prosecute, it blurred the line between the separation of powers. So this bill corrects that. So this would not require a constitutional amendment.
I'm kind of struggling with that because the Court of Criminal Appeals ruled that the Attorney General did not have the power that he was claiming, and that by prosecuting these types of cases, he was in violation, or the office was in violation of the Constitution. So I'm struggling with that court ruling, the rule that these powers previously were unconstitutional.
Mm-hmm.
Wouldn't we have to modify the Constitution in order to grant the Attorney General this power that they currently do not have under the Court of Criminal Appeals?
No, so first of all, the Attorney General does more than civil. There's human trafficking, there's significant criminal cases that they do prosecute. But if you look at the legislation last time, the issue that the Criminal Court of Appeals presented was that you essentially had two different jurisdictions that were prosecuting the crime. So there had to be a separation. They also said it was unconstitutional because there was an overlap in responsibility. So this bill addresses that by it says there is no more overlap. The local district attorney has 6 months to determine whether they want to prosecute or not, investigate and prosecute. And if not, then it's at the option of the Attorney General. So there's a clear separation. There is no overlap.
Did the court not hold that district and county attorneys have prosecutorial power in the state, and that power is exclusively theirs, except in very limited circumstances?
Yes, they specifically said that the local prosecutor, they can engage the Attorney General for help, but they have to make that request. So what this legislation does is it allows them a 6-month time period where they can choose whether to prosecute or not, investigate and prosecute. And if they don't, then the option goes to the Attorney General. So again, you have that separation.
Okay, I just don't see why we would need a dual level of prosecution when county and district attorneys have that authority under the Constitution. But thank you for discussing it with me.
Members, are further questions of Representative Shaheen at this time? Seeing none, we will call you back shortly. You have a few witnesses.
Okay, thank you.
Chair calls Debbie Lindstrom, I'm sorry. Record shows you're Debbie Lindstrom. You're testifying on behalf of Citizens Defending Freedom and yourself, and you're for the bill. Is that correct?
Yes, sir.
Please proceed.
Chairman King and honorable committee members, my name is Debbie Lindstrom, and I'm with Citizens Defending Freedom, and I support this bill. Lady Justice's blindfold represents a sacred promise. That law applies equally to everyone. But what happens when that blindfold is pierced by political calculation? When some prosecutors decide certain laws aren't worth enforcing? For too long in Texas, we've witnessed election violations reported, evidence gathered, and then silence. Not because evidence was lacking, but because some local prosecutors chose inaction over justice. In December 2021, the Court of Criminal Appeals stripped the Attorney General of authority held for nearly 70 years, creating a dangerous vacuum where election lawbreakers find safe harbor in counties where prosecutors might look the other way. This isn't about politics, it's about protecting something fundamental. The ballot box is where Texans of every belief make their voices heard. When that sacred space is compromised, we all lose. HB 5138 offers balance. It preserves local control by giving county prosecutors 6 months to act. Only then does the Attorney General step in. Now, some will claim that this bill expands power. Some will say it's unnecessary. Please explain that to the Texans whose complaints have gathered dust while local prosecutors hide in cowardice and blame shift with a dismissive, "not my job." This isn't over, when future generations look back at this moment, let them say we stood guard over our republic's most sacred right with the same unwavering courage shown at the Alamo. Let them say we ensured that in Texas, election laws aren't just words on paper, but principles with power. Thank you.
Thank you very much for that testimony. Members, questions of the witness? Seeing none, thank you for being here. Chair calls Veronica Worms. Record shows you're Veronica Worms. You're testifying on behalf of Texas Civil Rights Project, and you're against the bill. Is that correct?
Yes, sir.
Please proceed.
Election fraud cases are exceedingly rare, yet this bill is expanding the Attorney General's power to unilaterally go after any perceived election code violation.
Hang on one second.
Okay.
I think your we're having trouble with that microphone.
Okay.
You want to grab the other microphone,
Sure.
please? We'll start over. Now try that one.
Thank you, sir. All right, let's try again. Election fraud cases are exceedingly rare, yet this bill is expanding the Attorney General's power to unilaterally go after any perceived election code violation in an end run around our highest criminal court's ruling determining that that was a matter for local district attorneys to decide. Despite the 2021 ruling restricting the AG's unilateral authority to prosecute voter fraud, his office has continued to aggressively pursue these cases on the taxpayer's dime, regardless of local law enforcement's ability and authority to do so themselves. It violates separation of powers to give this authority to the AG because, as the court in Stevens determined, local district and county attorneys have the exclusive power to determine whether and how criminal cases in their jurisdiction are prosecuted. Respectfully, to answer Representative Turner's question and confirm his understanding of the Stevens ruling, a constitutional amendment would in fact be required to resolve that issue. This is just one more installment of the legislature's attempts to expand the AG's powers unconstitutionally and simultaneously take prosecutorial discretion out of the hands of local DAs. DAs would not be able to control whether or not a report of an election offense was eventually prosecuted, no matter how flimsy the evidence is. That would be left up to the AG. Moreover, this bill even takes away prosecutorial discretion from the AG, as the bill would compel the AG to prosecute every single election offense that crossed his desk. Aside from our concern of state overreach, another concern for us is the potential of legislation like this to cause a chilling effect on voters, particularly those who are uncertain about their eligibility, deterring participation in our democracy. Safe and fair elections are of the utmost importance to both the public and the Texas Civil Rights Project. This is why we recommend improvements and investments in the Secretary of State voter education program and fund so that every eligible Texan hoping to participate in our democracy feels empowered to do so.
Thank you for your testimony. Members or questions of this witness? Seeing none, thank you for being here.
Thank you.
Chair calls Andrew Hendrickson. Record shows you're Andrew Hendrickson. You're testifying on behalf of ACLU of Texas, and you're against the bill. Is that correct?
That's correct.
Please proceed.
Thank you, Chair King. My name is Andrew Hendrickson, representing the ACLU of Texas against the bill. Respectfully to Chair Shaheen, I believe that the Shell versus May issue and the procedural issue here do not address the constitutional concerns raised in Stevens, and also longstanding doctrine here in Texas, been found by the Fifth Circuit in Baker v. Wade, as well as Financial Commission of Texas v. Norwood, the Texas Supreme Court, and the CCA in Texas v. Stevens, and earlier in a case called Meschel. I'll just take this part real quickly, as quickly as I can. The Texas Constitution in Article 2, Section 1 has an express separation of powers provision, unlike the federal Constitution, where it's implied by the structure. And the court has always held that that means that there has to, you can only never imply any grant of authority under the Constitution. It has to be expressed. In this case, that means that the Shell versus May, you're looking, what the court looked at in Stevens was the issue of whether the other duties shall be required by law, portion of the AG's duties under Article 4, Section 22, and said that the May there doesn't mean it's required by law. But they went on to say and that was what the lower court ruled in that case. What they went on to say was that was not the controlling issue in the case. The case comes down to separation of powers, and the legislature can't grant the authority to the AG to prosecute criminal cases absent a constitutional amendment when Article 5, Section 21 clearly vests that power in county and district attorneys. Also in the Meschel case, which is from 1987, again, this doctrine goes way back. It's actually over 100 years old. You see these cases. But under the Meschel case, the legislature is actually found to be in violation of separation of powers because they also make it clear that the county and district attorneys have exclusive control over preparation for trial and those types of situations about charging decisions. And so in doing so,
Thank you for that testimony.
Apologies.
Members or questions of this witness? Thank you, Mr. Hendrickson. Being here. All right, is there anyone else wish to testify on, for, or against House Bill 5138? Seeing none, Chair recognizes Representative Shaheen to close.
Thank you, Mr.
Members or
Chairman.
questions of Mr. Shaheen? Mr. Raymond.
Thank you, Chairman. Chairman, I'm sorry I wasn't here for your layout.
Sorry, you missed a good one.
You jumping around, we're all jumping around this morning. But I wanted to ask you, or maybe I should ask Chairman King, did the DA's Association, have they taken a position on this, district attorneys?
I'm not aware, sorry.
There was no testimony there.
Have you talked with, I deal with them all the time, but you haven't talked to the DA's Association?
Nobody from the
approached you?
DA's Association has come talk to us, no, sir.
They haven't approached you?
Not to my knowledge.
Who's your district attorney?
Greg Willis.
And so, have you talked to him? I'm just asking because I'm curious.
I haven't talked to very many people in my district, just to be honest with you lately, but no, I've not talked to them.
Okay,
In my layout, what I was trying to do was
Yeah.
address the concerns of the Criminal Court of Appeals, and specifically with the Criminal Court of Appeals, they used the specific word overlap. The Criminal Court of Appeals did not, said it was unconstitutional for there to be two different law enforcement entities overlapping as a separation of powers with respect to election law. So what this piece of legislation does is it creates separation in that the local district attorney has a 6-month period to determine whether they want to prosecute an election crime or not.
Right.
If they decide no, they're not going to, the attorney general then can do that. So by doing that, by separating it over those 6 months, it satisfies the point that the Criminal Court of Appeals was making.
About the overlap, you're saying so that, for 6 months, the local DA can decide if they want to move on it, and then if they don't, then it's sort of, then, although I guess I would argue, or I'm questioning, if the DA decides in 6 months not to pursue it, but they decide in month number 8 or 10, then they still could? Or does your law,
No.
or does your proposal take that away?
Once the 6-month time period elapses, then the Attorney General can.
Under your proposal.
Make a decision. Now, if the Attorney General says no, and, you know, your scenario, 8 months later, the district attorney or law enforcement gets new information, then they certainly can make a decision.
But having said that, because I apologize, Chairman,
That's
I have
fine.
not given this much thought
Yeah.
before now, but let's say it's month number 9,
Mm-hmm.
that the law, as I read your bill, law enforcement has submitted a report, you know, to the DA and to the Attorney General, right? So it's now 6 months, local DA hadn't done anything. Month number 7, Attorney General sort of starts jumping into it, and your bill says the local, the DA has to give them any information they have
That's
as they
right.
request it. So now it's month number 8 or 9. At that point, if the local DA says, you know what, as we've looked at it now for a little bit longer, I want to take this on. Does your bill contemplate then what would happen? Like, can they then take it back essentially from the Attorney General?
They would have to have that discussion with the Attorney General. So in this bill, there is provisions where both law enforcement entities can still work together. So there's specific language here that says the Attorney General can actually go to the district attorneys to help prosecute, what have you. So those two entities would just have to make a decision.
Okay. All right. Thank you.
Mr. Turner? Thank you, Mr. Chairman. Representative Shaheen, you just talked to Representative Raymond about, you know, this is trying to resolve the overlap in jurisdiction, but as I look at the opinion that ruled that found the Attorney General does not have this power, and that it's unconstitutional for the office to claim this power. The part I'm reading anyway isn't speaking so much about overlap, but it says clearly the Constitution already grants this authority to county and district attorneys. Because this is already the specific duty of county and district attorneys, the Court of Appeals erred by misconstruing the other duties clause to encompass judicial branch duties. If we were to adopt the reasoning of the court below, then the legislature could grant the Water Development Board with prosecutorial authority. Perhaps this is extreme, but it certainly emphasizes how relying on other duties would render meaningless the separation of powers. And so it seems to me the court is very clearly saying that it is a separation of powers violation for the Attorney General to claim to be granted this authority, even by the legislature, that's in violation of the Constitution, unless, of course, as you noted, a local prosecutor asks for the Attorney General's assistance in a prosecution, which they have the ability to do, and the Attorney General has the right to participate if asked. But
So-
the primacy for prosecution in the state rests with the local prosecutors.
So that is in reference to the wording of the legislation that was passed that said that the Attorney General may. So when you did may, it violated the separation of powers, because then it was saying both the district attorney and the Attorney General's office could prosecute the crime. So that's why this bill says shall, and it has that 6-month deviation. So now there's no overlap.
It would seem to me shall makes it worse.
No, it actually makes it clear. If you couple you shall prosecute and the local district attorney has 6 months, that's your separation. You may not agree with that, and this will probably get litigated, and the legislature often presses the lines, and items are resolved in court. I will tell you, I've had legal counsel look at this, and they believe it's solid and will prevail if and when it's challenged.
Okay, well, I just, as Ms. Thompson just said, I think it's been thoroughly litigated in our state's highest criminal court and found the Attorney General just simply doesn't have this
And we've
this authority.
accommodated their ruling in this legislation. We specifically took their ruling and produced this legislation.
Respectfully, it just seems like still you need a constitutional amendment to change the Constitution, which is what is required here. But thank you.
Sure.
Mr. Chairman.
Mr. Guerin.
Thank you, Mr. Chairman. Mr. Shaheen, what if the district attorney takes it to a grand jury and the grand jury no-bills it. So it's been in front of a grand jury of your peers, but then the AG decides, well, that's not good enough. Can they step in at that point?
No,
I mean, that
if it
would be
goes to-
the attorney general, excuse me, the district attorney at that point would have said, I choose not to prosecute. The way this bill's written, that would, to me, say he chose not to, so the AG can then decide, even though it has been to a grand jury and the grand jury no billed. Is that the intent of your legislation? Because that's the way it reads.
No, if the intent of legislation is the district attorney doesn't take any action, the way this is written, if they take that action, they take it to a grand jury, the attorney general cannot
In
step
your
in.
layout, you specifically said if the DA chooses not to do it within
That's right.
6 months.
If they don't investigate it and they don't prosecute it, then
Well,
the attorney general can step in.
It doesn't say if they don't investigate it, it says if they don't take any action.
Well, if you look at that area of code that's being updated, it talks about investigations and prosecutions. So in your scenario where they take it to a grand jury and the grand jury establishes that there's not evidence, the attorney general then cannot step in.
I disagree with the way,
Well, I'm happy to make
I
that
think that's your interpretation
clearer.
of it. The way I read it, it's not that way, and obviously neither one of us are attorneys.
That's
and so, we're talking about something that we probably don't know very much about.
And that's, I'm happy to adjust language, but the intent is certainly if the district attorney takes action.
I'm not worried about intent. I've seen intent out of that way, G's office before.
Yeah.
It ain't always good.
Yeah, so again, with respect to this legislation, I'm happy to make accommodations if something's not clear. Yes, sir.
All right, Mr. Anchia has a question.
Yeah.
Yeah, just one quick question, Chairman Shaheen. You said you visited with counsel on this. Did they give you a legal opinion or anything like that that you could circulate to the members of the committee?
No, I just gave them the bill and gave them and asked for their perspective as far as whether it would withstand a constitutional challenge or not. Would this be viewed as constitutional?
And was it constitutional lawyer? Sorry.
It was somebody that is very familiar with election law. I don't know if he's a constitutional lawyer or not.
Okay. Thank you.
Yes, sir.
Yeah.
Yes, sir. Mr. Guerin.
No, sir.
Mr. Raymond.
Yeah, Chairman, I just want to let you know, so I've, although I did not do it this session, I've been thinking about doing some legislation that would allow the Attorney General to come in on some other cases that what I'm thinking about, I think everybody here would support. So, you know, I'm not averse to the idea, what you're trying to do here as far as, you know, giving the AG more prosecutorial, you know, discretion or ability or whatever. But this one's a little different, right? And you don't have to, but I would suggest that it'd be good to talk to some DAs.
Sure.
That's just my suggestion.
I'll just leave you with this. I've given the nature of this, I've stressed the office of the Attorney General, right? So I'm talking about the Attorney General that will be in office 20 years from now, and I've tried to stress that. So.
Okay. Ms. Thompson.
I just want to ask a question. I noticed this doesn't cost any money, but we have over 100 bills that's filed this session where they want the Attorney General to intervene, from everything from your bill to being in the room when a woman's having a baby. Do you think that he's going to have enough time and staff if we don't give him some more money? How much these things going to cost?
Before the ruling, he had 354, I believe, open cases with for election law, and then after the Criminal Court of Appeals ruled, that dropped down to 50. So he had 300.
Have you seen the
cases go
legislation
away.
filed this session with all the bills that's requiring
I'm aware
Attorney
it's quite a
Generals?
bit, ma'am. Yes, ma'am.
Well, we got about 100 bills that's asking him to intercede in different cases, and I'm just wondering if he's going to have time for this.
Well, again, his
Thank you,
caseload
Mr.
with election law went down by 300 cases, so I believe he would have the resources. Yes, ma'am.
Members, further questions of Representative Shaheen? Seeing none.
I think I closed. If I didn't, I close.
You just did.
Thank you, sir.
If there's no objection, House Bill 5138 will be left pending. Is there objection? Chair hears none. House Bill 5138 is left pending.
Thank you, Mr. Chairman, members.
Let the record show that Ms. Hall is with us now. We're going to Bell. He was here first. Yeah. Chair lays out House Bill 5435 recognizes Chairman Bell to explain the bill.
Thank you, Chairman King and committee members, for the opportunity to lay out House Bill 5435. Last session, I authored and passed House Bill 2518 to improve transparency in public-private partnerships by requiring leases to include payment and performance bonds, including a 90-day notice before starting construction. While this works well in most cases, we've since learned it has created challenges for institutions of higher education that manage projects in emergency situations where exact details like scope, contractors, and cost aren't known 90 days in advance. This requirement has delayed needed work and increased costs unnecessarily. The language of this bill defines an emergency, changing it from 90 days to 30 days. There will be a committee substitute later with minor changes to this language addressing institutions of higher education specifically. Thank you, Mr. Chairman, members, for your consideration. I'm glad to answer any questions. I do believe there's a resource witness available if needed, and I would respectfully request the opportunity to close.
We do not see any witnesses. Okay. Huh? We do have a resource witness, if anybody needs one. No? Okay. Is there anyone who wishes to testify on for or against House Bill 5435? Seeing none, Chair recognizes Chairman Bell to close on House Bill 5435.
Thank you, Mr. Chairman, members, and I would appreciate your favorable consideration. I close.
If there's no objection, House Bill 5435 be left pending. Is there objection? Chair hears none. House Bill 5435 is left pending. All right. Chair lays out House Bill 5269. Chair offers up a committee substitute to House Bill 5269 and recognizes Freshman Berry to explain the bill.
Freshman Berry here. Thank you, Mr. Chairman and members. It's a pleasure to, ma'am. Well, I appreciate the opportunity to be here. Thank you, Mr. Chairman and members. The Texas utility industry relies on valuable insights from the Office of Public Utility Counsel, or OPUC, to represent the voices of residential and small business ratepayers. When it comes to understanding the impact of regulatory changes on constituents, the OPUC plays an important role in translating complex market data into clear insights that inform sound public policy. To advocate effectively for consumers, the OPUC must have timely, accurate information from the Public Utility Commission, ERCOT, and electric utilities to conduct thorough analysis and report on relevant trends. I do have a committee substitute that refines the language added that outlines that OPUC's additional authority ensures that OPUC can receive requested information electronically and free of charge, and further clarifies the confidentiality of information submitted to OPUC. House Bill 5269 gives express statutory authority for the OPUC to request and receive market data relating to reliability, generation, transmission planning and distribution, and systems resiliency from the PUC, ERCOT, and different electric utilities. This bill also ensures that any confidential information under current law retains the same level of confidentiality when submitted to OPUC. I'm happy to answer any questions and defer to OPUC's Public Counsel, Benjamin Barkley.
All right. Members, are questions of Mr. Berry? Seeing none, I've got one. Do you know what time State Affairs gavel's in?
8 a.m.
Okay, I was just curious if your staff made you aware of that. There was a motion to withdraw your bill since you didn't know what time we started.
I understand that, and I apologize for being late.
Thank you.
Thank
You
y'all.
do have a witness. We'll call you right
You
back.
got
Chair calls Cyrus Reed. Record shows you're Cyrus Reed. You're testifying on behalf of Lone Star Chapter Sierra Club, and you're for the bill. Is that correct?
Yes, I'll be very brief. I have written testimony. If you need it, it should be distributed in your Dropbox. If anyone wants a copy, I've got them here.
You like to kill trees. We get it. Please proceed.
I like to recycle the trees. OPUC is a small but mighty agency. They represent residential consumers, small business consumers. They need to have the tools for very complex rate cases, but especially ERCOT protocol changes, things like transmission planning, things like reliability standards. They need the same information that other folks have so they can better represent consumers, and we very much support Freshman Berry's excellent bill. And with that, I'm happy to answer any questions.
Members or questions, Mr. Reed, Mr. McQueenie.
Do you think you could provide Freshman Berry with a wristwatch of some sort? Thank you.
Well, having timely information is very important to OPUC and very important to Freshman Berry as well. So timely information is important.
Thank you, Mr. Reed, for being here. If there's no further questions of this witness. All right. Is there anyone else wish to testify on, for, or against House Bill 5269? Seeing none, Chair recognizes the esteemed Representative Berry to close briefly on his bill.
Thank you, Mr. Chairman.
Yep, Mr. Raymond.
Thank you, Chairman. So I'm curious, do you think this would help lower utility rates for consumers, for your constituents?
I think what it's going to do is it's actually going to provide data consistency across all agencies. And I think when you have data consistency, you actually have more efficient use of time and energy.
Man, you just started and you didn't answer my question. You're like, do you think it will lower utility rates for consumers, your constituents?
That's the goal. Ultimately,
Do you think that this will?
I do.
You do?
I do.
How do you think it'll lower them?
Well, anytime you can provide consistent market data analysis throughout the agency, you can make better decisions.
So you think consistent market data will lead to lower utility rates?
I do.
How'd you come to that conclusion? Don't mind.
Right. Members, there are other questions of Mr.
Wait,
Berry.
I do
Mr.
have-
Darby.
Is this your first bill layout for State Affairs?
It is not my first bill layout, but it is my first bill layout in this esteemed committee.
Have you given due deference to the committee chair and members of the committee for allowing you to lay out this bill?
I have.
Do y'all feel honored?
Okay. Well, I'm a little concerned that his first bill before the State Affairs Committee, the only support seems to be Cyrus, but, you know.
I would like to know.
He could do better, you know. Not that we don't appreciate Cyrus being here,
We
but.
all appreciate Cyrus, right?
So.
I'm good. Although I did have a question as to whether he understood what OPUC even meant before he assumed the office of state representative. Is this kind of newfound knowledge?
No, it's not.
What?
Being in city government previously, I had a little bit of insight to it. I at least knew what the acronym meant.
Okay, thank you.
Chairman,
Mr. Raymond.
One more thing. In fairness to you, okay, been on this committee a while and we've kind of picked up the signals. So when Cyrus Reed testifies and he gives us, because he gives us his testimony in paper, but it's different colors. And when he gives it to us yellow, that's code for slow down, watch out, not sure. It's not green, it's not go. And believe me, he gives it to us in green, or it's in red, means it sucks, right? So when it's yellow, he's telling us, yes, I'm testifying for it, but it's yellow, guys. And so watch out. So I just want you to know he's not really for you 100%.
I appreciate that. I hadn't picked up on the color coding, but I appreciate the insight.
All right. Members, is there anyone else that would like to pick on Freshman Berry? Seeing none, I think we already did that part.
Thank you, Mr. Chairman.
All
I
right.
close.
Thank you for that closing. The committee substitutes withdrawn. If there's no objection, House Bill 5269 will be left pending. Is there objection? Chair hears none. House Bill 5269 is left pending. Mr. Lalani, where is he? All right. Chair lays out House Bill 842, recognizes Representative Lalani to explain the bill.
Good morning, Chairman King, Vice Chair Hernandez, members of the committee. Thank you for giving me the opportunity to lay out this bill. Living in Texas Gulf Coast region for many decades, I have learned that hurricanes are part of life. While we will never be able to prevent them, we can minimize the damages caused to our communities. My bill HB 842 directs the Public Utility Commission to conduct a comprehensive study on the potential cost and savings of burying overhead power lines in the Gulf Coast region defined as within 150 miles of Gulf of Mexico. Since 1980, Texas has seen 190 confirmed weather disaster and losses exceeding $1 billion in each storm. Recently, Hurricane Beryl, especially destructive to overhead power lines, leaving millions of Texans without power for weeks due to high wind damaging the power lines. Too many Texans tragically lost their lives due to the storm associated with power outage. Hurricane Beryl caused $1.2 billion in damages to CenterPoint electrical infrastructure. Although some reports cite that potential high upfront cost of burying power lines, many studies have demonstrated that underground systems immediately begin to pay for themselves through long-term economic benefits. Underground power lines have proven to be more resilient to severe weather events. In this way, it is crucial to think the underground power lines is an investment rather than a purchase. According to the study by Scenic America, there are many economic advantages of underground power lines. Texans could expect fewer interruptions to business activity due to fewer power outages. Maintenance costs to power lines, especially after weather costs, are often lower due to less damage. It would also eliminate the need to trim trees near the overhead power lines, resulting in cost savings. Removing overhead power lines also improves the beauty of our neighborhood. Texans can benefit from their homes from that one. HB 842 would ask the Commission is tasked to evaluating the cost associated with burying existing power lines and maintenance and repair cost of underground power lines, potential savings obtained from minimizing these outages, and how to leverage emerging technologies from initiative like Department of Energy Grid overall program. HB 842 is an essential first step in saving lives, saving billions of dollars in economic impact. This study is also essential, will provide clarity to the costs associated with taking this undertaking. It helps to identify which will be the most cost efficient to bury lines and how much investment is needed. I've invited also Ms. Therese Harris of Public Utility Commission to be the resource witness here on our behalf. Chairman and members, I'm happy to answer any questions. Otherwise, there is a right to close.
All right, members, or questions? Mr. Leilani. Seeing none, you do have a witness. We'll bring you back shortly. Chair calls Sally Bacco. Sally Bacco. All right, we're going to show Sally Bacco was going to testify on behalf of the city of Galveston and is for the bill, not testifying. Is there anyone else who wishes to testify on, for, or against House Bill 842? Seeing none, the chair recognizes Representative Leilani to close on the bill.
Thank you. If there are no questions, I close.
There are questions for the, Mr. McQueenie.
Do you expect a fiscal note on this thing? I'm just curious what this study would cost.
Yes, we just learned last night about $1 million.
$1 million. Thank you. Thank you, Mr. Chair.
Okay. Members, are further questions? Seeing none? All right. If there's no objection, House Bill 842 will be left pending. Is there objection? Chair hears none. House Bill 842 is left pending.
Thank you.
Yeah. Do you want to do Darwin? I don't see anybody else here. Okay. What number is it? Chair lays out House Bill 5111, recognizes Chairman Darby to explain the bill.
Thank you, Mr. Chairman. Members, this bill seeks to modernize and strengthen the regulatory framework surrounding campaign treasurer appointments in Texas. The current statutory structure governing campaign treasurers has remained largely unchanged since 1987. Despite the evolution of campaign finance practices and the increasing complexity of political operations, House Bill 5111 establishes clear eligibility requirements for individuals serving as campaign treasurers. Under the bill, a person must be at least 18 years of age and a legal Texas resident to serve. Individuals are disqualified if they currently serve as a treasurer for another campaign or a PAC and have been convicted of certain offenses, are registered lobbyists, or employed by a political committee. These provisions are designed to ensure that those entrusted with the oversight of campaign funds meet basic standards of independence and integrity. One of the most significant reforms in this bill is the prohibition on a person serving simultaneously as treasurer for both a candidate and a political action committee. While candidates and PACs are barred from coordinating under the law, there is currently no restriction on shared treasurers, a loophole that has been flagged by the Texas Ethics Commission and one that compromises both transparency and accountability. This bill also improves transparency in campaign treasurer disclosures by expanding the required information to include date of birth, resident and email addresses, and government-issued identification numbers, along with a signed affidavit affirming eligibility. In order to safeguard privacy, this bill also mandates that sensitive information be redacted prior to public posting. These are the same requirements as for someone who makes a donation to a political campaign. Furthermore, this bill ensures clarity and accountability in political committees, naming by requiring specific purpose committees to include the name of the supported or opposed candidate in the committee's name. These requirements also extend to assistant campaign treasurers to ensure consistency across filings. Members, this bill offers a common sense update to outdated campaign finance statutes. It promotes transparency, closes enforcement gaps, and empowers the Texas Ethics Commission to ensure the integrity of our election system. Be glad to try to answer any questions the committee may have with regard to the bill.
Members, there are questions of Mr. Darby this time.
Sure.
Ms. Davis.
Thank you. Did you say you wanted them to provide their Texas driver's license and all that stuff, and ID? You want their fingerprints and, I mean, what?
I don't think
Could
we
be a
said
treasurer,
fingerprints.
you
I
know,
don't think we said
fingerprints.
date of birth. Well, if it's a government-issued identification number, I don't think the license itself, but
So it's either state ID or license.
correct.
And so are we encouraging participation in the process or discouraging it?
I think we always encourage participation, but we want to make sure that the participants are who they say they are, and that they are not
A phantom person or something?
being non-transparent in who they're working for. We're trying to add to transparency. We saw in this last election cycle were political action committees out of this state.
We could bar them and we could fix that, but okay.
I'm sorry?
We could bar them out of the state and we could fix that real quick.
Well, that would probably be another bill, but
Okay.
I'd probably support that.
I was just curious, because one of the challenges has been, and always continues, has been with the citizens wanting to participate, but feel like that we would get too personal, too into their personal, and they're not the candidate. I respect and appreciate the notion of knowing who the treasurers are and what they do, and I don't have a problem with that. I just don't want us to get overly aggressive on the treasurers when we could do it differently. I mean, I think the PACs create a problem, and we keep talking about campaign reform. We could do it much easier by just telling you can only get money from your district, and we could stop a whole bunch of stuff. Thank you.
No comment on that last.
All right. Members, are further questions of Chairman Darby at this time? Seeing none, there is one witness so far. Chair calls Tony McDonald. Tony McDonald. All right. Tony must have run somewhere else. We're going to show Tony McDonald was here to testify on behalf of himself and against the bill not testifying. All right, is there anyone else wish to testify on, for, or against House Bill 5111? See,
Chairman, just for the record, I heard that Tony McDonald changed his mind and he wants to be for the bill. I don't know if you want to correct the record on that.
is there anyone else wish to testify on, for, or against House Bill 5111? Seeing none, Chair recognizes Chairman Darby to close on his bill.
Thank you, Mr. Chairman. Members are now closed.
All right. If there's no objection, House Bill 5111 be left pending. Is there objection? Chair hears none. House Bill 5111 is left pending. We'll go with Richard. All right. Chair lays out House Bill 3896. Chair offers up a committee substitute to House Bill 3896 and recognizes Representative Raymond to explain the bill.
Thank you, Chairman. And thank you for laying out the committee substitute. Members, this is an important bill for Laredo, for my district. As Laredo grows, and we're growing largely because of the fact that we've become the busiest port, not only in America, but in the Western Hemisphere. As Laredo grows, we have a need for more housing, city services. We have good jobs, but we need more infrastructure, especially energy and water. Laredo is growing very quickly, while the Rio Grande River, our only source of drinking water, is dwindling. When we have boil water notices regularly, it's a very serious issue. We need all the help we can get, and one strategy is being proposed in my district is to develop a desalination water treatment facility that will draw from the Carrizo-Wilcox Aquifer, providing a second water source for Laredo and surrounding areas. Currently, water supply corporations can generate power for their own use, and desalination takes a lot of energy. However, the cost for design and construction of these power generation facilities can be cost prohibitive. Without more support on this project, it's expected that the increased cost of water and sewer service to customers would be unaffordable to many Laredoans. This bill allows nonprofit water supply corporations to sell excess power generation back to the ERCOT grid. With that allowance, these water corporations would also be able to apply for state funding through the Texas Energy Fund, including completion bonus grants. As an accountability measure, water supply companies that choose to generate electricity intended for wholesale must register as a power generation company as well. The substitute has added language for clarification on the allowable uses of the energy produced. It is also amended subsection B to clarify that if a water supply corporation generates electricity for wholesale, it will be required to register as a power generation company and comply with the associated statutes. Also, I want to thank Walt Baum. We all know Walt. He is working with us to perfect this bill. There are a couple little words that we feel like we've got to add to, but I want to get it just right. So, Chairman, I and members, we'll come back to you before a vote. It won't be much different, but I think at that point it'll be as close to a perfect bill as we could get it. So with that, members, we want Texans to pay less for their utilities while retaining quality and dependability. This bill assures the ability of necessary and innovative water supply corporations to not only reduce the current demand on power resources by generating their own, but to additionally provide excess power in the areas of the state with the most need. I hope, members, that you can support me on this small change that will make a big difference for Laredo, especially for communities and other communities, especially for communities trying everything we can to be able to afford something as simple as reliable water sources. Thank you, Chairman, members. Appreciate your consideration.
Members, are there questions for Mr. Raymond? Seeing none, you do have one witness. We'll call you
Yes.
back shortly. Chair calls Petrus Wasdorf. Did I say your name correctly?
You did, yes, sir.
All right, then the record reflects that you are Petrus Wasdorf. You are testifying on behalf of SE Legacy, and you're for the bill. Is that correct?
That's correct.
Please proceed.
Thank you. I think Mr. Raymond laid out the bill well. We are, looking to develop area in Webb County, and one of the challenges is water availability in that area. And in addition to water availability, it's the cost to pump that water from the aquifer. We just laid out another bill this morning that dealt with that, and this one complements that in providing the ability to not only generate power for our own use, but sell that excess power to, among other things, other customers of the Water Supply Corporation, and just generally back to the ERCOT grid. And so we would appreciate your consideration of that bill. As Representative Raymond said, we're working with Walt on some clarifying language on some concerns that they had, and hope to get that out, and hope you all will vote this bill out at that time.
Thank you for that testimony. Members, are questions of this witness? Seeing none? Thank you for being here. Is there anyone else wish to testify on, for, or against House Bill 3896? Seeing none, Chair recognizes Representative Raymond to close.
Thank you, Chairman. We're trying to be creative in a responsible way, and I think we're doing that with this bill. This bill will help a lot, so I'd appreciate your consideration. With that, I close.
Do you have any idea when you might have your clarifying language to?
Probably in 2 or 3 hours. We can vote it today. I promise you that.
It won't be voted today, but we're
But
going
it'll
to
be
vote.
ready. No,
we're
it'll
going
be
to vote
ready
this week. So
it was almost ready this morning, Chairman, but we wanted to make sure that we got it exactly right. So it'll be ready today.
Okay, perfect.
Thank you.
Members, are there any other questions, Mr. Raymond? Seeing none? All right. The committee substitute is withdrawn. If there's no objection, House Bill 3896 will be left pending. Is there objection? Chair hears none. House Bill 3896 is left pending. I'll do my bill, I guess. She's gone. What is it? Chair lays out House Bill 5323. Members, thank you for giving me the opportunity to lay out House Bill 5323. House Bill 5323 establishes the Texas Energy Waste Advisory Committee, bringing together leaders from key state agencies to focus on one major goal: ensuring a more reliable and efficient power system for all Texas, reducing energy waste. The committee will meet regularly and review the recommended ways that state programs can cut down on wasted energy, boost energy efficiency in homes, buildings, infrastructure, and support demand response programs. This is especially important for ERCOT, which manages the grid that powers most of Texas. The committee will focus on high-risk periods like extreme heat or cold, when demand puts the grid reliability at risk. By improving existing programs, the committee can help strengthen the grid without the need to build expensive new infrastructure. Members include leaders from the PUC, ERCOT, and the Comptroller's Office, and other key agencies to ensure coordinated statewide effort. Finally, the committee will report to the legislature every 2 years with its findings and recommendations. With that, I would ask for the opportunity to close and would try to answer questions. All right, seeing none, there are some witnesses. Chair calls Will McAdams. Record shows you're Will McAdams. You're testifying on behalf of Texas Advanced Energy Business Alliance, and you're for the bill. Is that correct?
Yes, sir.
Please
Mr. Chairman.
proceed.
Thank you, Mr. Chairman. Members of the committee, as stated, my name's Will McAdams. I'm testifying on behalf of TABA in strong support of House Bill 5323. So this bill is designed to provide a unity of purpose for disparate energy efficiency and demand response programs administered by up to 5 state agencies. Energy efficiency programs and targets have been around for more than 25 years in Texas, developed and managed by the PUC, State Energy Conservation Office and the Comptroller, TERP and TCEQ, weatherization programs at TDHCA, natural disaster and recovery programs at the GLO, and technology accreditation and appliance installation programs at TDLR. Many of these agencies manage over $3 billion in federal and state funds dedicated to increasing the promulgation of energy-efficient technology and potentially up to 4 gigawatts of demand response in the ERCOT region. So, for over 25 years, each of these programs has acted independently without a common goal. House Bill 5323 acknowledges this, that things must change. The bill recognizes that we have a reliability standard that was ordered in Senate Bill 3 in 2021, which this committee passed into law. The standard, which the PUC adopted last year, sets a reliability target based on the frequency, magnitude, and duration of outages that Texas consumers could experience over high-risk hours, both during summer and winter. The bill requires that these state agencies talk to each other, nothing more, make recommendations on how their programs could be modified or enhanced to help Texas achieve its reliability targets as a part of that standard moving forward. And we appreciate the opportunity to support this bill.
Thank you, Will. Members, are there questions of this witness? Seeing none, thank you for being here.
Thanks, sir.
Chair calls Cyrus Reed. Uh-oh. All right. Record shows you're Cyrus Reed. You're testifying on behalf of Lone Star Chapter Sierra Club. You're for the bill.
Very much so. And I have the color yellow, which of course is purity and divine love and joy, which I wore on Easter Sunday. So very much for the bill. Will said pretty much everything I wanted to say. I would point out, you know this, Chairman King, that when we've had real trouble on our grid, it's usually because of inefficient buildings and old heating systems or cooling systems that we need to resolve that causes a lot of our reliability issues. So if we can get these agencies to actually coordinate and improve the programs, and there's some other similar bills that would do this as well, but this bill, what's important about it is it sets it to a reliability standard and really gets those agencies coordinating. We would suggest, if you would like, Texas Facilities Commission that does our state buildings, and the Water Development Board, because Mr. Raymond knows this, there's a real connection between water and energy, and they have programs as well. So those might be some other agencies that you might consider adding, but in strong support of joy, revival, energy efficiency, demand response, and reducing energy waste with the color yellow.
Thank you, Mr. Reed.
Thank you.
Members, are there questions of Mr. Reed?
Chairman,
Mr. Raymond.
I wanted to ask if you do in fact amend your bill to take some of the suggestions, would you be open to the chairman adding the Sierra Club, you know, to be on the, I'm kidding, man.
So to answer your question,
was kidding.
This is a
No, I was
coordinated,
kidding.
this is
I mean, no.
coordination of state agencies. This is not a regulatory bill or one that needs other stakeholders. Stakeholders can absolutely give their input to this advisory committee, but yeah, I would not anticipate that the Sierra Club would be a member of a committee, and I would not be advocating for that. We will make our positions known to these folks, but we don't need to be on the committee. But thank you for the suggestion.
Thank you, Mr. Reed.
I'm always happy to help. Thanks.
Members, other questions of Mr. Turner?
Just a comment, Mr. Chairman. I think this is a great bill, and Cyrus raises a good point about the Facilities Commission, given how much state office building square footage we have. On the same vein, it might make sense to consider the Higher Education Coordinating Board, just thinking about how much square footage and facilities we have in our four-year institutions. That'd be another opportunity to save some energy.
Absolutely.
Thank you.
All right. Members, further questions? Thank you, Cyrus, for being here.
Thank you.
Chair calls Matthew Bombs. Matthew Bombs. All right, we're going to show Matthew Bombs was here to testify on behalf of Texas Advanced Energy Business Alliance and was for the bill, not testifying. All right, is there anyone else wish to testify on, for, or against House Bill 5323? Seeing none. Chair recognizes the chair to close on House Bill 5323. Members, are there questions of me? If there's no questions, if there's no objection, House Bill 5323 will be left pending. Is there objection? Chair hears none. House Bill 5323 is left pending. Where's it? Here? All right. Members, when we come back from the floor, we have a few bills left, and I intend on taking up pending business. So if everybody could be here, that'd be fantastic. Chair moves that the committee stand in recess until final adjournment, recess, or of the House, or during the referral, if permission is granted. Is there objection? Hearing none, the motion prevails. Committee stands in recess. Committee on State Affairs come to order. Clerk, call the roll.
Chairman King?
Here.
Vice Chair Hernandez? Anchia?
Here.
Darby? Davis? Garen? Gian? Hall? McQueenie? Metcalf? Thielen? Raymond? Smithy? Thompson? Turner? That's Smithy.
Oh, let the record show that Representative Smith is here. Okay. Are these all? Yeah. Are we bringing? Oh, that 8 in it. Oh, the record reflect that Vice Chair Hernandez is on the dais. Okay. You're close. All right. The chair lays out as pending business, House Bill 3278. Members, this is Representative McLaughlin's bill that requires a study on incentives and use of solar wind energy. Chair moves that House Bill 3278 without amendment be reported favorably to the full House recommendation that it do pass to be printed. Clerk, call the roll.
Vice Chair Hernandez? No. Anchia? No. Darby?
No.
Davis? No. Garen?
Yes.
Gian?
Pass. I'll go at the end.
Okay. Hall?
Yes.
McQueenie?
Yes.
Metcalf?
Yes.
Phelan? Raymond?
No.
Smithy?
No.
Thompson?
No.
Turner?
No.
Gian?
You want to vote no?
It's not going to pass either way.
No.
It is not going to pass. Chair King?
Aye.
6 to 9.
There's 6 ayes, 9 nays. The motion fails. Chair lays out as pending business, House Bill 3356. Members, this is Chairman Patterson's bill regarding the reliability requirements for certain generators. Representative Garen offers up as committee substitute. Is there objection to the adoption of the committee substitute? Chair hears none. Sub is adopted. Mhm. Oh.
I don't mind voting for it, I don't bring it up.
Well, you already did.
Then I can change my vote.
And, but before we proceed, I believe Mr. Anchia had some comments.
Yeah, thank you, Mr. Chairman, for the recognition. I just want to remind everybody that this bill, according to a recent study, would increase
electricity costs by about $5 billion and over over 6 million per large industrial customer and about $200 per Texas family per year. $200. It doesn't achieve reliability. This bill is going to drive resources out of the market. It's going to undermine reliability. And just 2 weeks ago, we heard from Pablo Vegas here when he briefed us on ERCOT's load projections, showing a 75% spike in peak demand in just 5 to 6 years. We need every electron, members. I asked him specifically if in today's market structure with no new mandates, we could meet that spike in peak, and he said yes. And he called Texas's current regulatory environment well suited to support ERCOT's growth. And this bill would upend that with fairly heavy-handed and big government mandates and interference. 2 years ago, we debated firming in this very room, and Chairman Hunter repeatedly asked, who pays for this firming? And the answer was consistent, our customers. Thank you, Mr. Chairman and members of the committee for indulging that statement of vote.
Thank you, Mr. Anchia. Mr. Darby.
If you'll indulge me, Mr. Chairman, also. I speak in strong opposition to the committee substitute for this bill. I represent a West Texas district with nearly 8 gigawatts of installed and planned wind and solar projects. This bill threatens the economic backbone of rural districts like mine by undermining one of the greatest success stories we have in this state. Across the state, and especially in rural areas, current and future renewable projects are expected to generate over $50 billion in landowner payments and local tax revenue. That money stays in our communities, supporting farmers and ranchers, funding volunteer fire departments, and revitalization of main streets. School districts have issued bonds based upon the projected revenue. House Bill 3356 puts those financial commitments at risk. We should be working to protect prosperity in rural Texas, not undercut it. This is a solution in search of a problem that rural Texas, quite frankly, can't afford. Thank you.
Ms. Davis.
Thank you, Mr. Chairman. I'd just like to mention when the hearing came up, I asked, was this something we were doing retroactive? And in fact, it is, and it creates a real precedent when we don't keep our word here at the legislature. While I wasn't on the committee when it's passed, I think the legislature voted for it, and to undermine it before it's worked through the system is just not what we want to do.
Thank you. Members, Mr. Smith.
Mr. Chairman, I won't take up any of the committee's time except the last 3 speakers I totally agree with. I think every one of the speakers on the committee committee members made a good and valid point. So.
Thank you. Anybody else? Seeing none. Speaker Phelan moves that House Bill 3356 as substituted be reported favorably to the full House. The recommendation that it do pass be printed. Clerk call the roll.
Vice Chair Hernandez. No. Anchia.
No.
Darby.
No.
Davis.
No.
Guerin.
Yes.
Guillen.
Yes.
Hall. Yes. McQueenie.
Yep.
Metcalf.
Yes.
Phelan.
Yes.
Raymond.
Yes.
Smithy.
No.
Thompson.
No.
Turner.
No.
Chair King.
Aye. Okay. There being 8 ayes and 7 nays, the motion prevails. Chair lays out as pending business House Bill 3778. Members, this Representative Louderback's bill relating to geothermal energy being considered dispatchable power. Chair offers up a committee substitute. Is there objection to the adoption of the substitute? Chair hears none. Sub is adopted. Representative Darby moves that House Bill 3778 as substituted be reported favorably. The full House recommendation that do pass be printed. Clerk call the roll.
Vice Chair Hernandez. Anchia. Darby. Davis. Guerin. Guillen. Hall.
Louderback.
McQueenie. Metcalf. Phelan. Raymond. Smithy. Thompson. Turner. Chair King.
Aye.
15-0.
There have been 15 ayes, 0 nays. Motion prevails. Chair lays out as pending business House Bill 4581. Members, this is Chairman Guillen's bill regarding temporary emergency energy facilities. Chair offers up committee substitute. Is there objection to the substitute? Chair hears none. Sub is adopted. Representative Raymond moves that House Bill 4581 as substituted be reported favorably to the full House. Recommendation that it do pass be printed. Clerk call the roll.
Vice Chair Hernandez. Anchia. Darby. Davis. Garen. Gian. Hall. McQueenie. Metcalf. Phelan. Raymond. Smithy. Thompson. Turner. Chair King.
Aye.
15-0.
There being 15 ayes, 0 nays, the motion prevails. Chair lays out as pending business Senate Bill 1358. Members, this is a companion to House Bill 2625 by Representative Dealia that we previously voted out relating to the regulation of noise for late-night deliveries at restaurants. Chair moves that Senate Bill 1358, without amendment, be reported favorably to the full House. Recommendation that it do pass be printed. Clerk call the roll.
Vice Chair Hernandez. Anchia.
No.
Darby. Davis. Garen. Gian. Hall. McQueenie. Metcalf. Phelan. Raymond. Smithy. Thompson. Turner. Chair King.
Aye.
12 to 3.
There being 12 ayes and 3 nays, the motion prevails. Chair lays out House Bill 5109. Members, this is Chairman Darby's bill that is identical to Vice Chair Hernandez's bill. We previously voted out that allows SECO to adopt energy efficiency rules. Chair moves that Senate Bill 13.
Sorry, House Bill 51.
Sorry. All right, we didn't change that. Hang on a minute. Now we're moving. Yeah. Chair moves that House Bill 5109, without amendment, be reported favorably to the full House. Recommendation that do pass be printed. Clerk call the roll.
Vice Chair Hernandez. Anchia. Darby. Davis. Garen. Gian. Hall. McQueenie. Metcalf. Phelan. Raymond. Smithy. Thompson. Turner. Chair King.
Aye. There are 15 ayes, 0 nays, motion prevails. Okay. Chair recalls House Bill 3713 from the Subcommittee on Telecommunications and Broadband. Chair lays out House Bill 3713 and recognizes Chairman Anchia to explain the measure.
Thank you, members. This is Chairman Capriglione's bill that we heard in the subcommittee. Currently, local exchange companies and cooperatives serving fewer than 3,100 access lines face financial challenges in maintaining reasonable rates for local exchange service. And additionally, changes in commission policies or federal regulations can lead to significant revenue reductions, putting the financial stability of these smaller providers at risk. Without adequate mechanisms to address these reductions, these companies may struggle to sustain their services or implement necessary expansions. The existing framework under Chapter 56 of the Utilities Code provides some authority to maintain rates, but lacks specific mechanisms for addressing revenue shortfalls caused by regulatory changes. Expanding the Universal Service Fund to cover these shortfalls would help maintain service affordability and availability in rural areas and less densely populated areas.
Members, other questions for Chairman Anchia? Seeing none. Oh, Ms. Davis, I'm sorry.
What's the cost? I don't see the fiscal note. What's the fiscal note on that?
Let me look. I don't believe there's a fiscal note. In fact, there's probably a positive fiscal note to this, but I will get you that answer, Madam Chair.
All the material is on Dropbox.
Oh, good. Yes, all the materials on Dropbox, members. Oh, here we go. I do have it. I do have it in this. No significant fiscal impact to the state. It is assumed that any costs associated with the bill could be absorbed using existing resources, and no local government impact either.
How do you have no, I mean, I want to understand how do we absorb that?
Is there some, I don't know,
Yeah.
if there's somebody from
Your-
LBB. I didn't
your
prepare the fiscal
microphone's
note.
still not on, Ms. Davis. If you have another question.
Yeah, the question was, I was trying to understand when it says that implementing funding mechanisms, it sounds like that would be a cost. I just wanted to understand, how do we absorb that?
The USF already exists is where I think you're getting the no fiscal impact. But we can ask for.
You don't know?
What I
that's
told you
fine.
is what I know is the USF already exists, so I don't believe this would cause more of a fiscal impact than's already there, is why it says there's no
Thank you.
significant impact.
Thank you.
And lastly, Mr. Chairman, I'd like to note that while we did not take a vote in committee, 4 members were present.
Okay. Members, are there further questions of Chairman Anchia? Seeing none, the chair moves that House Bill 3713 without amendment be reported favorably. The full House recommendation that do pass be printed. Clerk call the roll.
Vice Chair Hernandez. Mejia.
Aye.
Darby. Davis. Guerin. Gian. Hull. McQueenie. Metcalf. Phelan. Raymond. Smithy.
No.
Thompson. Turner. Chair King.
Aye.
14 ayes.
There being 14 ayes, 1 nay, the motion prevails. Chair recalls, is that right, Senate Bill?
Yeah.
Chair recalls Senate Bill 1121 from the Subcommittee on Telecommunications and Broadband. Chair lays out Senate Bill 1121, recognizes Chairman Anchia to explain the measure.
Mr. Chairman, would you like Chairman Metcalf to, since he is here and this is his bill, to explain it?
We will recognize Chairman Metcalf.
Thank you, Mr. Chair and members. This bill simply adds buried fiber and communication infrastructure projects located entirely within a right-of-way of an existing road to the list of exemptions. We heard this in committee, and there was no opposition to the testimony, and I don't remember how many were present at the meeting, but we believe it's a good bill, and I appreciate the recommendation for it to be voted out of State Affairs.
Members, questions for either Chairman Anchia or Chairman Metcalf? Seeing none.
Thank you, Mr. Chairman, members.
Chair moves that Senate Bill 1121 without amendment be reported favorably to the full House. Recommendation do pass be printed. Clerk call the roll.
Vice Chair Hernandez. Anchia.
Aye.
Darby. Davis. Guerin. Gian. Hull. McQueenie. Metcalf. Phelan. Raymond. Smithy. Thompson. Turner. Chair King.
Aye.
15-0.
There being 15 ayes, 0 nays, motion prevails. Chair lays out Senate Bill 326. Members, this is the companion to House Bill 2391 by Chairman Campriglione regarding the definition of anti-Semitism. Chair moves that Senate Bill 326 without amendment be reported favorably to the full House with the recommendation that it do pass be printed. Clerk call the roll.
Vice Chair Hernandez. Anchia. Darby. Davis. Guerin. Gian. Hull. McQueenie. Metcalf. Phelan. Raymond. Smithy. Thompson. Turner. Chair King.
Aye.
15-0.
There have been 15 ayes, 0 nays, the motion prevails. Chair lays out Senate Bill 783. Members, this is a companion to House Bill 1360 by Vice Chair Hernandez relating to allowing SECO to develop energy-efficient regulations. The chair moves that Senate Bill 783 without amendment be reported favorably to the full House. Recommendation that it do pass be printed. Clerk call the roll.
Vice Chair Hernandez. Anchia. Darby. Davis. Guerin. Gian. Hull. McQueenie. Metcalf. Phelan. Raymond. Smithy. Thompson. Turner. Chair King.
Aye.
15-0.
There being 15 ayes, 0 nays, the motion prevails. Chair lays out Senate Bill 1197. Members, this is the companion to HB 3272 by Chairman Guerin relating to drones over spaceports. Representative Darby moves that Senate Bill 1197 without amendment be reported favorably to the full House. Recommendation that it do pass be printed. Clerk call the roll.
Vice Chair Hernandez. Anchia. Darby. Davis. Guerin. Gian. Hull. McQueenie. Metcalf. Phelan. Raymond. Smithy. Thompson. Turner. Chair King.
Aye. There being 15 ayes, 0 nays. Motion prevails. Members, that is all of our pending business for today. However, we do expect to have a formal tomorrow. What time? Around 1 o'clock. I know you're all excited about that. Be great to see you there. Okay. We're going to go. Let's do Slauson. The SJR first? Okay. Okay. Chair lays out SJR 40 and recognizes Representative Slauson to explain the resolution.
Thank you, Mr. Chairman and members. This SJR works in tandem with an SB that'll be before you in a little bit to address how we handle as a state the period of time following disaster or emergency declarations and the emergency powers of the governor, the legislature, and how those interact. We actually had near identical legislation before this committee that we voted out favorably last session. And in the 87th before that, we also took up topically. I think after working through this with the Senate author and members of our chamber, I think we have kind of finessed this into what will be the right size solution for Texas. The events of the last few years brought to light the inadequacies in the disaster and emergency response when we saw that Texas was the last legislature in the country to convene after COVID reached us. All 254 counties of our state were impacted, but our constituents didn't have their voices heard for quite some time down here. The legislation before you right today is to amend our response that was passed back in 1975 with Model Acts. This is not in regard to Governor Abbott, who clearly acted within the letter of the law and demonstrated great concern for his fellow citizens in coordinating the response to COVID at that time. Having said that, it is imperative that the legislature have the ability to assert itself as the will of our governed, not just during the 5 months that we're here, but also have that opportunity during a 19-month interim. SJR 40 seeks to realign those powers in a couple of key ways by requiring that the governor would call a special session if a disaster or emergency declaration is to exceed 30 days, or in the event of a nuclear or radiological event, if that if that event would exceed 90 days, and if one of 3 thresholds is met. In the SJR version that's in front of you, those thresholds are that at least half of the state's population is affected, or that situation exists in at least 2/5 of the counties in this state, or 101 affected counties, or at least 2/3 of the counties in 3 or more of our trauma service areas are affected. We will have a committee sub to you very shortly to tighten that up a little bit further so that we are not inadvertently triggering special sessions for every fire, flood, hurricane, but only in those circumstances where the legislature should gather back in Austin. SJR 40 also creates a very limited cause of action to give a sitting member of the legislature the opportunity to file a suit with the Texas Supreme Court to initiate that special session should the executive branch not call it in. I thank you for your time on this one, and I would yield for any questions that you may have.
Members, any questions? Representative Raymond?
Thank you, Madam Chair. And thank you for bringing this and continuing to work on it. I was one who formally asked the governor at the time to call us into special session, and believed then, as I do now, that he should have. I might add that the MAGA world all agreed with me on that, if you know what that means. if you know what that means. But seriously, what you're doing here, did you say if it's, we would be called in if he declared an emergency that lasted 30 days? Is that what you said?
If it was going to be renewed beyond the first 30 days.
Okay, so
And
if he
it meets-
calls, if he declares a disaster or emergency, and let's say he does it, June the 1st, right? And then it ends on June the 25th, right? 24 days later or whatever. And then 2 weeks later, he calls us, declares another state of emergency, same part of the state or whatever. Does this contemplate that? And let me ask this, maybe I should ask you this. Have you been working with the governor's office on this? Has the governor and his staff opined or worked with you all on shaping this thing or not?
I can't speak to whether or not the Senate author worked with them. Our office has not since we received this.
You have not?
I have not. I have worked with the Senate author and with members in our chamber. I have, but I can't speak to whether the Senate author coordinated with
So
the
you
governor's
didn't,
office.
you didn't reach out to them or they didn't respond or?
Neither.
Huh?
I did not reach out to them.
Okay. Well, this is such a sensitive deal, right? That, then I'll ask you the question again that I asked a while ago. Let's see if you can. So he issued an emergency declaration June the 1st and lifts it on June the 25th, 24 days later. And then 2 weeks later, he issues it again. What does this bill contemplate what happens in that situation?
I believe that the Senate bill we're going to discuss contemplates successive issuances, but I don't think that the SJR.
Okay. So the SJR, is it going to be a lot different from what we have in front of us, or is it going to be pretty similar?
In the sub? Is that your
Yeah, in the
question?
sub.
I can tell you it'll be very similar. The difference on it would be instead of a triggering event of 2/5 of counties, we would raise it to 3/5. And then on page 1 of the JR, under C3, we would be clarifying that that section applies for a medical or public health emergency or disaster, since that's involving the trauma service regions.
Mm-hmm.
And the point of those, Representative, is to, as we went back through all the different declarations that had been issued in the last 15 years, to winnow down the situations that would have triggered us back into a legislative session to just events that involved a significant portion of the state and not every drought declaration or flood or fire that didn't involve a more substantial number of counties.
Let me ask you this. Were this to pass, and let's say it had passed 5, 10 years ago, what would have happened in your view when the pandemic then hit?
The first declaration issued by the governor's office would have provided 30 days. To renew it at that point, because that declaration covered 254 counties,
Right.
would have required calling us back into session. When the legislature showed up into session, the options before us could have been to bless the governor's actions and tell him move forward. It could have been for us to modify the.
Yeah, we could basically do anything, right?
Yes.
If we came
Or
in.
terminate it if we wanted to
Right,
terminate.
we could do anything if we came in. So had it been in place, and then looking back, we're able to look back now and see how long it really sort of lasted and so forth. Had this been in place, he would have declared an emergency at some point. I can't remember if it was around April by the time he finally did it, or March.
I believe it was March.
And of 2020. So then, if this were in place already, we would have definitely come back in. I mean, we would have had a legislative session, right? Because they would have wanted to extend it clearly because things were getting worse 30 days later, not better. They just continued to get worse for many months, right? So likelihood is he would have called us back in because he would have wanted to extend the emergency declaration, right? Is that right?
I would think so, and Representative, I would imagine that we would have been in agreement that we may have had some different conditions that we might have wanted to see or not see.
Yeah, so, I
Based
mean,
on
had it been in
constituent
place, you know, and I understand, I mean, I don't want to say anything bad about the governor either, because he's a great guy, good friend, all that stuff, but looking back on it, are there some things, if you can recall, and if you can't, that's fine, some things that he did during the pandemic with which you did not agree? And if you want me to give you some examples, I will, but do you know of any that you can think of that you didn't agree with?
Well, I want to be clear that it's very easy for me to sit in hindsight and second guess some of those decisions that were made at the time, and it would have been a much more difficult thing to be a member here in this body trying to figure those out too. So while I might, and I think in fairness, we have passed some bills since then about keeping churches open, for example.
I know,
So
that's
we have
one of my
examples of
bills,
things that we
yes.
would have done differently had we been in session.
Yeah.
Um,
Well, in any event, so this is a really important thing because I hate to think this way, but I have to imagine that something's going to happen. There are going to be some other things that happen in the future. And I really believe very strongly that the legislature needed to come in, and that the people, not that the governor doesn't represent the people, but I think that when you got something this big, or that you know, the legislature is more likely, or maybe it's just better for us to engage in figuring out how we move forward instead of putting it all on one guy, which is what we did. We kind of said, hey, we're going to put it on you. Here you go. Knock yourself out. And so as you shape this thing, again, if you want to address this, or maybe you can't right now, but the scenario I gave you, that he calls a declaration for 25 days and stops it, lifts it, and then 10 days later, or 2 weeks later, calls it again, and 20 days later, lifts it, and then 10 days later calls it again. You see, and I don't mean this governor, I mean whoever's there at the time. I always say, try not to look at the personality, but just the position, right?
To the policy, correct.
Yeah, and so whether your bill sort of thinks about that, and maybe it's too hard to figure it out, I don't know. Maybe it's just too hard to figure it out. But in the case of the pandemic, for example, clearly it ended up going for years, arguably, right? So had he done a declaration, lifted it 25 days later, 10 days later declared it again, lifted it 20 days later, 10 days later lifted it again, it's a way to get around what you're doing as it's written right now, I think. And so I'm trying to figure out how we take away the temptation from a Gavin Newsom or someone like that, if they're governor, right? So that's all. This is a big deal for me. This is something I cared a lot about, and I know 2 sessions ago, then Chairman Burrows had the bill in front of us that would have kicked in a special session, right? And we had the hearing, and then I don't think we even voted out of committee, as I recall. I don't think we even voted on it.
In the 87th, I don't remember.
Yeah, you were on there, right? Mm-hmm. I don't think we voted it out. I don't think we voted on it. Not because people that came and testified didn't want it. The people, you'll remember this, the people that came and testified overwhelmingly wanted for the legislature to be called into session. They wanted the bill. And it was a pretty tame bill. It was strong, but it wasn't that strong. So if we're going to do it, all I ask is that you try to look at it a little more about figuring out the scenario I laid out for you, where a governor would be tempted by staff and others maybe to game it. Okay?
I'd be happy to talk about that. It is touched on a little bit in the SB when we get to that, but it might need another tweak to address specifically what you're saying.
But thank you for bringing it.
Thank you.
Any other questions? All right. I don't believe we have any witnesses. Is there anyone who wishes to testify on, for, or against SJR 40? Seeing none, Chair recognizes Representative Slauson to close on the resolution.
I close. Thank you.
If there's no objection, SJR 40 will be left pending. Is there objection? The chair hears none. SJR 40 is left pending. Chair lays out SB 871 and recognizes Representative Slauson to explain the bill.
Thank you, Madam Chair. This is the second piece of the reforms to the Emergency Powers Act. SB 871 codifies that call for a session, and there the thresholds were set out in the JR. The SB provides a distinction between disasters and emergencies and the powers that are implicated under the two different types of declarations. Under this bill, disasters are limited to acts of God or man-made catastrophes that are not associated with violence or force. And emergency powers are designated as the response for acts of terror, warfare, and situations where citizen conduct has deteriorated to unrest, riot, or revolt. SB 871 localizes emergency declarations under Chapter 433 to ensure that an incident in East Texas doesn't change the laws, liberties, or lives of people in West Texas, and that it provides also that only the legislature may impair the operation or occupancy of a class of business during an emergency or disaster. It would require that the governor's office and any relevant agency to publish a list of actively suspended statutes on their websites to make it easy for citizens and businesses to determine what has been suspended. It also limits the governor's suspension powers during disasters while still leaving nearly all of those powers intact, except that he cannot suspend the Disaster Act itself, the Emergency Act, or a provision related to sunset of an agency of the state. The bill provides that the governor cannot suspend provisions of the election code relating to qualifications or procedures for accepting a voter. And I believe that covers the highlights of this bill, though you may have some questions that I would be happy to entertain, especially.
Any questions? Right. Again, we don't have anyone registered to testify. Is there anyone who wishes to testify on, for, or against SB 871? Hearing none, the chair recognizes Representative Slauson to close on the bill.
The only other thing, Madam Chair, I would offer is to Representative Raymond that on page 4, I think section C1 may address a question you had earlier, and I would be happy to work with you on that section if it does not. And thank you, Madam Chair. I close.
Thank you. If there's no objection, SB 871 will be left pending. Is there objection? The chair hears none, and SB 871 is left pending. The chair lays out HB 2844 and recognizes Chairman Landgraf to explain the bill.
Thank you, Madam Chair. I appreciate the opportunity to lay out House Bill 2844. This bill seeks to reduce permitting burdens on food trucks, particularly for those operating in multiple cities or across multiple counties. Under current law, if a food truck wants to serve customers in 2 different communities or 2 different jurisdictions, it has to go through 2 separate permitting processes, one for each of those different jurisdictions. So that means that twice the paperwork, twice the inspections, twice the costs, and of course, it could be much more than that in many cases. And if that food truck operator wants to expand into even more communities, obviously those costs stack up as well. The problem gets even worse in major metropolitan areas where there are more jurisdictions at play. These regulations are putting unnecessary pressure on small business owners, making it more difficult for them to grow and offer their services for more Texans. House Bill 2844, as filed, aims to fix that by creating a single statewide license for food trucks. But Madam Chair, I do want to make a very important note that we are working on a much narrower committee substitute that we actually have, but unfortunately did not receive it in time to lay it out for the committee today. But the committee sub would focus solely on the health licensing side of the issue and those provisions that are in the bill that I am laying out today. So I understand that there are probably some witnesses who are going to testify about some of the preemption issues with regard to time, place, and manner restrictions. My intention is not to preempt municipal or county regulations of that, so I just want to be very clear because there probably will be some questions about that. Really, if you're looking at the bill that I'm laying out, the part that I do want to keep are the provisions that are related to having a single license to make sure that there is a uniform standard across the state for health and safety for the patrons of these food trucks. So I just want to make that note that before I ask the committee to vote anything out with regard to 2844, it would be with some of those changes in mind. Madam Chair, I'm happy to answer any questions.
Any questions? All right, we have a few witnesses.
Great. Thank you.
Chair calls Marcel Elizondo. We have you registered as Marcel Elizondo, representing Texas Environmental Health Association and yourself, and you are testifying against House Bill 2844.
Correct.
You may
Thank you, Madam
proceed.
Chair, council members. My name is Marcel Elizondo, and I serve as an executive board member of the Texas Environmental Health Association. I'm here today representing the dedicated professionals in local health departments across the entire state who are responsible for protecting public health through the inspection of the rapidly growing industry of mobile food vendors. I'm here to express opposition to House Bill 2844. This bill proposes removing the requirement for mobile food vending establishments to obtain permits from local jurisdiction and instead shifts that function to the state. While we recognize the intent to streamline regulation, this bill would significantly undermine the ability of local health professionals to effectively regulate mobile food vendors. Eliminating local jurisdictional authority would also result in an inefficient oversight model, particularly given the likely staffing challenges at the state level. Local health departments serve as the first point of contact for small business owners. We would lose that ability to provide timely consultations, inspections, and support despite being most familiar with local ordinances. I would also note that legislation passed by Chairman Cabriglione last session granted Dallas and Tarrant counties the authority to issue a countywide mobile food permit. He has legislation that was heard last week in Intergovernmental Affairs, House Bill 1449, that would expand that bill to all large counties in Texas. House Bill 2844 removes oversight tools from local health authorities without providing a viable or adequately resourced alternative. I respectfully urge this committee to reconsider the bill's potential impacts on public health and work with local governments to find solutions while preserving the local safeguards that protect all Texans.
Thank you. Any questions? Thank you. Chair calls Blaine Rasmussen. Did I say that correctly?
You did.
All right, we have you registered as Blaine Rasmussen, representing On the Hook Fish and Chips, and you're testifying for House Bill 2844.
That is correct.
You may proceed.
Thank you, Chairman and members of the committee. I'm the Vice President of On the Hook Fish and Chips, a food truck company operating 19 trucks across 26 states, including Connecticut and Illinois. We employ over 150 people and have 10 regional headquarters. We're well-versed in licensing requirements when it comes to food trucks, but no state presents a greater challenge than Texas. We currently spend over $21,000 a year on business licenses in Texas alone. One of our 3 full-time scheduling employees is almost completely tied up with managing Texas permits. And despite our resources and track record, there are many cities in Texas where we still can't serve. Some cities are outright hostile towards food truck operators. Many times our licensing department will work with the city for weeks, only to be shut down at the last minute by code enforcement over obscure technicalities. For instance, a phone number on the side of the truck being a 1/4 inch too small. Many cities require burdensome zoning procedures that no host properties that we like to partner with have been able to successfully complete. If you compare this to states like Florida, Utah, and Tennessee, where we've been able to operate with ease, these states have food trucks operate under a single reciprocal permit. These states have run their system this way for years, and it works, with clear, consistent rules that support both health standards and small businesses. House Bill 2844 would help fix these problems. It would streamline Texas's regulatory landscape for food truck operators, aligning it with proven models like Florida, Utah, and Tennessee, places that protect public health without punishing entrepreneurs. Like others, we want to expand our business in Texas. We have a franchise program, but we have declined to offer our franchises in Texas because we know it would not be worth the time of a new entrepreneur to navigate the process here. We need clear regulations that recognize and support the mobility of food trucks. Thank you for your time, and I'm happy to answer any questions.
Thank you. Any questions? Thank you. Chair calls Samuel Hooper. We have you registered as Samuel Hooper, representing the Institute for Justice and yourself, testifying for House Bill 2844.
Yes, that's correct.
You may proceed.
Thank you, Madam Chair, members of the committee. My name is Samuel Hooper. I'm Legislative Counsel at the Institute for Justice. We're a non-profit law firm that focuses on issues of economic liberty, and we are very strongly in support of this bill. IJ takes particular interest in this issue because we litigate cases defending food trucks from unreasonable bureaucratic overreach by city governments all the time. We've won cases in El Paso, in San Antonio, and in South Padre Island, just to name some of our most recent ones. And having a single statewide license is going to be enormously beneficial. It's going to get rid of this mishmash of overlapping contradictory requirements that food trucks currently have to navigate. Just having a single statewide license is going to be enormously beneficial. There are some concerns, as there always are with issues like this, about preemption. And we see the same thing with housing, for example. Oh, why are we trying to take the power of local municipalities away? Local control is very important for truly local issues, but as the bill sponsor correctly identified, mobile food trucks tend to operate across municipal boundaries, and then it's very important for them to face a standardized regulatory regime rather than having to adapt to slightly different circumstances on the ground in different places. So that would be enormously beneficial. I understand that there's a committee substitute that's going to narrow the focus of the bill, and really the single statewide license is the biggest piece, and that on its own is going to be enormously beneficial. So we're very strongly supportive, based on our experience litigating these cases, defending food trucks from what is unfortunately often blatantly protectionist behavior by local cities. So we're very strongly supportive. I'm happy to take any questions the committee might have. Thank you.
Thank you. Any questions? All right. Thank you.
Thank you.
Chair calls Shane Linkos. Shane Linkos. All right, we'll show Shane registered representing the State Office of Administrative Hearings, neutral on the House Bill 2844, did not testify. Sarah Lewis. We have you registered as Sarah Lewis, representing the Food Truck League, DFW, and yourself, testifying for House Bill 2844.
Yes, ma'am.
You may proceed.
Good evening, esteemed committee members. My name is Sarah Lewis, and I am a food truck event coordinator for the Food Truck League, DFW. Our business matches the best food trucks with clients to create unique events. In my role, I've organized dozens of food truck events and worked closely with many food truck owners, witnessing firsthand how the current patchwork of city and county regulations stifles vendors' growth and opportunities. Because of my experience organizing vendors, I strongly support this bill to streamline food truck regulations. Right now, food trucks in Texas must obtain separate permits for every city they operate in, each with its own fees, paperwork, and timing for approvals. This is difficult for both cities and for trucks. We've had instances where we couldn't organize food truck events in certain cities because their truck regulations were too complicated and time-consuming. Sometimes fantastic food trucks can't go to certain communities because of a lack of time or funds to get the required permits. The status quo is crushing small businesses. I've seen food trucks forced to close because they can't afford the cumulative costs of multiple permits, which can quickly add up to thousands of dollars a year. In contrast, states like Utah and Georgia have passed similar reforms to House Bill 2844, resulting in vibrant food truck industries. HB 2844 would create similar opportunities here in Texas. My company was involved in getting the Food Truck Freedom Bill passed in Utah, and we've seen incredible growth in food truck entrepreneurship since its passing. By simplifying regulations, this bill would open doors for trucks in major metro areas like Dallas, Fort Worth, and Houston, while empowering rural trucks to access bigger markets. Smaller and rural communities would also gain greater access to diverse food options if trucks could actually travel to them, as trucks are designed to do, which would enrich local economies and culture. This bill is a win for small businesses, innovation, and communities across Texas. I urge you to support it and give our Texas food trucks the freedom to flourish. Thank you.
Any questions? Thank you. Chair calls Monica Juneau. Monica Juneau. We'll show Monica Juneau, registered representing If Jesus Made Quesadillas, in favor of House Bill 2844 and did not testify. Jamie Coffey. We'll show Jamie Coffey, registered representing If Jesus Made Quesadillas and self, for House Bill 2844, did not testify. Gerardo Garcia. We have you registered as Gerardo Garcia, representing Chero's Latin Kitchen and Self, and you are for House Bill 2844?
Correct.
You may proceed.
Thank you. Good afternoon. My name is Gerardo Garcia, and we are the owners of Chero Latin Kitchen. We are a Salvadoran family-run food business operating as a mobile food vendor in the Dallas-Fort Worth area. And I'm here today to voice my strong support for House Bill 2844 because as a small business owner, we've experienced the excessive challenges that mobile food vendors face under the current system. Running a food truck or trailer should be about serving great food, offering great customer service, and growing a business. But instead, it often feels like the biggest job is navigating through the red tape for the current system. Things that we face while acquiring these permits in every city and every county has its own permitting purposes and rules. Multiple health permits, redundant inspections, stacked fees, and some cities require commissary kitchens with different specific standards. Others require in-person application costing us time and business. The system is expensive, unpredictable, and some permits are really slow, can take weeks or even months to acquire. Inconsistent, conflicting rules around parking, inspections, and operations. This House Bill 2844 would create a statewide standardized system, simplifying the process and eliminating duplication. Let vendors like us focus on feeding our communities and growing the business. It's about fairness, opportunity, and economic growth. And I urge all of you to support House Bill 2844 and help mobile food vendors thrive. And at Chero's, the word Chero means friend in Salvadorian slang. And I'm here asking you to be a Chero, a friend to small business today. And any of you are ever in the DFW area, I know of a Pusa place. Thank you.
Thank you. Any questions? Thank you. Chair calls Brett Silva. Brett Silva. We'll show Brett Silva, registered on behalf of Food Truck and Self for House Bill 2844, did not testify. Chloe Beck. We have you registered as Chloe Beck on behalf of State Office of Administrative Hearings, neutral on the bill.
Yes, ma'am.
You may proceed.
I'm here as a resource from the State Office of Administrative Hearings, and I'm happy to answer any questions y'all may have. We also just wanted to point out in the bill, there are a couple of timelines for the SOA contested case process. We're the agency that conducts those hearings for the Department of State Health Services. I believe there's a 14-day deadline and a 7-day deadline contemplated in the bill in an expedited form. And we would just suggest considering extending that maybe to 17 days to match the Board of Nursing statute for their suspension. It just tends to be a bit more feasible to get those hearings done within that time capacity. The APA actually requires 10-day notice be provided to a party to these cases. So to provide that notice and then be able to hold the hearing within 7 days just might not be possible. So that would just be one note, and we're happy to help anybody make suggestions for that language.
I believe Representative McQueenie has a question.
Thank you, Madam Vice Chairman. Your agency would play specifically what role? Is it issuing this permit or just if there is a complaint about a truck?
It's the back end, so it would be any enforcement actions, the revocation and the suspensions, and the administrative penalties.
And you feel that your agency is capable of handling that without issue?
I believe we put a bit of the cost onto the fiscal note, but it would be pretty nominal depending on the volume of the caseload. I believe we said one ALJ would be required to meet the statewide demand for these enforcement actions.
Great, thank you.
Mm-hmm. Any other questions? Thank you.
Thank you.
Madison Gessner. We have you registered as Madison Gessner on behalf of the Texas Restaurant Association, and you are testifying on House Bill 2844?
Yes, ma'am.
Go
Thank you. Hi, I will be brief. I'm sure I'm the last of many, but the TRA represents the state's $137.8 billion food service industry, which encompasses about 57,000 food and beverage establishments across the state, and we employ 1.5 million Texans. And many of these locations and members are food trucks. We are respectfully testifying on House Bill 2844 today. We support Chair Landgraf's goal to consolidate food truck licensing and inspections so that small businesses do not have to navigate different rules in different locations. However, we do have some concerns about unintended consequences with a few of the provisions in the version of the bill you have before you today. For example, we've asked that the requirements for employees to get their food handler or food manager certifications be consistent across food trucks and restaurants as they are today. Secondly, we also think it's important to go back to current law in terms of the way that the Texas Department of State Health Services conducts and reports health inspections today. This is a complicated yet transparent process that is working well today for food trucks and restaurants, and importantly, going back to the current law on this bill does not undermine the goal of Chair Landgraf's bill. After discussing these concerns with his office, we think we're going to be able to address them in a future version of the bill, which is why we're neutral today. We're very grateful to Chair Landgraf and his staff for the positive conversations we've had so far, and we look forward to working with them to get to a good resolution on House Bill 2844.
Thank you. Any questions? Thank you. Is there anyone else who wishes to testify on, for, or against House Bill 2844? Seeing none, the chair recognizes Chairman Landgraf to close on House Bill 2844.
Thank you, Madam Vice Chair. I really appreciate this, and I do appreciate the testimony. Hopefully some of you, hopefully you did as well. Let me just address a couple of things from the SOA witness. That 17-day period that she mentioned sounds very reasonable to me, and I'm happy to work to make that change so that it's consistent with some of the other timelines that SOA has to work with. Also very happy to work with some of the other stakeholders, including the brick and mortar restaurants, to make sure that we do have some uniform standards there. What we're really looking for is to have this one permit that has a uniform health and safety standard for the entire state of Texas so that we don't have to stack all of those permits depending on where the mobile food truck is operating. I think it was great to hear from these operators who are putting their blood, sweat, and tears into building their businesses, and if they just have one uniform standard to meet that still protects the health and safety of their customers, then I think that's a win for everybody. So as I said, we do have a committee substitute that looks like we might have even one more tweak, but the bill that is laid out that does include most of those provisions is something that I would like for you and the rest of the committee to favorably consider at the appropriate time. And unless there are any questions, I'll close.
Any questions? All right, thank you.
Thank you.
All right, if there's no objection, House Bill 2844 will be left pending. Is there objection? The chair hears none. House Bill 2844 is left pending.
That's a timely phone call by Mr. Garrett.
Chair lays out House Bill 5247. The chair offers a committee substitute to House Bill 5247, and chair recognizes Representative McQueenie to explain the bill.
Thank you, Madam Vice Chairwoman. I'm recognized to lay out Chairman Garrett's bill. It's related to alternative capital recovery process for certain utilities. Last session, the legislature passed House Bill 5066 in order to finally provide the transmission capacity needed to expand the electrification of oil and gas and other vibrant industries in West Texas. The PUC has approved a plan that will provide over $12 billion of new transmission capability to this region, with that transmission needed to be energized by as close to 2030, as soon as 2030. Some of the utilities responsible for building this needed infrastructure already have historically large capital investment plans in Texas as booming growth, and it makes a need for upgrades to the grid for reliability. This unprecedented investment puts significant pressure on the utilities' financials, with the result of some of these utilities having already been downgraded with their credit ratings and others facing likely downgrades. Credit downgrades are a big deal because they raise the cost of borrowing capital that's needed to make this investment. Ultimately, it'll raise the cost for our constituents as they pay their electric bills. House Bill 5247 provides a very targeted solution to bridge this period of hyper-growth investment some of our utilities are in, while simultaneously enabling these utilities to maintain a solid credit rating. This is important for them, and it's important for Texans. House Bill 5247 allows ERCOT transmission and distribution utilities that are building for the Permian to opt into a streamlined and annual filing process in lieu of tracker rate adjustment filings that the PUC has a process for today. This would likely simplify as well as reduce the workload of the PUC. The PUC would get double the time it has today to process these cases, but use the exact same oversight and calculations that are used today to ensure reasonableness and for any of their utilities investments. Additionally, this single annual processing will properly refresh the overall cost allocation benefiting residential and small commercial consumers. But to be clear, this bill still requires that the new transmission and distribution must actually be built and in service before a utility can ask for it to be included in its rate. It maintains the ability of the PUC to fully review these costs, and is a limited mechanism that expires once the utility's investment falls to a more normal traditional level. The committee substitute adds an additional protections for our constituents, including clarity with regard to how the utility opts into this process, as well as notification requirements for the utility when it's no longer eligible. Any utility that opts into this simplified process will not be allowed to earn more than their authorized return set by the PUC in the utility's most recent rate case. The substitute also ensures that the revenues from new customers are taken into account when setting the rates, as well as allowing the PUC to expressly account for this mechanism when it sets the utility's return on equity in a full comprehensive rate case. Finally, utilities are incentivized to timely complete their PBRP transmission build, as they can lose some of the benefit of this mechanism if their infrastructure is not energized by 12/31 of 2030. I will respectfully accept any questions and likely turn it over to Chair Karen to handle them.
Members, any questions?
Madam
Right.
Chair, I apologize, but for some reason our doors were locked and we were breaking the Open Meetings Act. and so I was tending to that, and I apologize for not being here to lay it out.
Anything else you'd like to add, Mr.?
No, ma'am. Thank you.
Right, we'll proceed to public testimony. Thomas Bricado. We have you registered as Thomas Bricado, representing Steering Committee of Cities served by Encore in the Texas Coalition for Affordable Power, testifying against House Bill 5247.
Most of that's correct. Good evening.
What's incorrect?
Okay, if I may, I am Thomas Bricado, but
Well, no,
on
no,
behalf
because
of-
we have to make sure it's clear in the record. Which part is incorrect?
I'm registered against the bill, but I'm requesting that you change my position to being on the bill, if you will, and I
On the bill.
apologize for any inconvenience.
We will change your position to on.
I am Thomas Bricado, and I am testifying on behalf of OCFC and TCAP.
All right, thank you.
We've expressed our concerns to Representative Guerin's office and look forward to continuing discussions. Additionally, we're still reviewing a draft substitute from some of the stakeholders. Cities support reliable electric service and affordable electric rates. Additionally, cities acknowledge the current growth cycle in Texas and the challenges utilities are navigating as a result of this growth. There are reasonable aspects to this bill. Our primary concern, however, is that HB 5247 would change more than 50 years of regulatory rate making by allowing utilities to prematurely receive a profit on facilities before the costs are included in rates. This extraordinary form of recovery is unnecessary because electric utilities already avail themselves of multiple expedited filings that allow for timely cost recovery. And many of these existing mechanisms are available to electric utilities more than once a year. Now, the filed bill and presumably the committee substitute would eliminate some of these filings, which is a good thing, but at a high cost, and it would shift risk from shareholders to ratepayers. The bill has the potential to incentivize utilities to spend inefficiently and excessively, and it has the potential for gold plating. And this is what drives up ratepayer cost. The last thing ratepayers in Texas need right now is a mechanism that increases utility profits unnecessarily. That said, utilities and other stakeholders have discussed improvements to this bill, such as accounting for load growth, reconciling any over-earning, and other changes. And accordingly, we're interested in working on HB 5247 with Representative Guerin and his staff. Happy to answer any questions.
Any questions? All right, thank you.
Thank you. And so, again, sorry for the confusion.
Brian Lloyd. We have you registered as Brian Lloyd, representing Encore Electric Delivery, testifying for House Bill 5247.
Yes, ma'am.
You may proceed.
Thank you, Vice Chair Hernandez, members of the committee. I am Brian Lloyd, Vice President, Regulatory Policy for Encore Electric Delivery, in strong support of House Bill 5247. As many of you know, we're Encore's largest transmission and distribution utility. We will be responsible for a large portion of the Permian Basin transmission buildup. Mr. McQueen did an excellent job laying out the bill, by the way. I am here to answer any questions you have about the mechanics of how this bill will work, but I do want to reiterate some of what we've talked to many of you about and contextualizing this for Encore. Earlier this year, we announced our official $36 billion five-year capital plan, with the reality that that will likely be closer to $48 billion once we get the needed regulatory approvals for our build-out. We are excited to meet the needs of the Permian and the rest of Texas, but it is severely stressing our financial metrics. Each year, we will need to borrow $4 to $5 billion in new debt to fund this build-out, but the credit rating agencies have indicated that they will soon downgrade us, raising our cost of debt, which is bad for us and for our customers. We will also need our owners to reinvest all of the earnings out of our business, plus give us billions more in capital at a time where regulatory lag makes our earnings very low compared to what the PUC authorizes. And we will need, as Mr. Bricado said, these frequent rate adjustments that we've been doing. On the other side of this hypergrowth, we do expect fewer rate adjustments, more customers to pay for the investment, and to issue less debt at a better credit rating. And House Bill 5247 gives us that bridge to get there. As long as we are massively negative, cash flow negative, it takes these 6 annual tracker filings we do today and collapse them into a single annual filing, while pulling in the mechanism that we are currently using for our system resiliency plan investments from Mr. Metcalf's bill last session. That will help reduce our lag. So again, to reiterate what the committee substitute and House Bill 5247 does not do, it does not give us money before we have already spent it, built the lines, and are serving new customers. Document those costs to the PUC, and we give the PUC more time, not less, to review those costs. It does not change the ability of the PUC to later say we acted imprudently or gold-plated, to use Mr. Brigado's term.
Thank you.
And I'm happy to answer any questions.
Thank you. Chairman Guerin.
Ryan, thank you for being here today, and thank you, Madam Chair. Does this substitute ensure that revenues from new customers are taken into account?
Yes, sir.
And so, as well, does it allow the PUC to expressly account for the mechanism when the utilities return is equal in a full comprehensive rate case?
Yes, sir.
Does it create any new rate recovery tools, or does it simply use the existing procedures?
It does not create new tools. What it does is, as I mentioned, take these 6 trackers, collapse them into one, pulls in this mechanism that helps us with our lag from the system resiliency plan. We're using that mechanism today in our procedures, but it's the same calculations that we're using today, just in this single procedure.
So this substitute would reduce the work at PUC, not increase the work, is that right?
For utilities that opt in, yes.
Will this prevent a downgrade for utilities? Because I understand y'all have been warned that your credit rating is going to be downgraded.
What I can tell you is, without new tools from the legislature or constructive rate case outcomes from the PUC, we're pretty certain we will get downgraded. I think the agencies have been clear. This mechanism will severely help with that, as well as a constructive rate case. And then there may be other things, but we think this will go a long way toward helping us maintain our current credit ratings.
So if you're downgraded, that not only does it cause your cost to go up, but it also makes it harder for you to borrow the money to do this. Is that right?
That's exactly right. Every time we go down a notch in our credit rating, there is a smaller pool of investors for us to get debt from, and it is at a higher cost.
Does it allow utilities to increase their profits?
It does not. Again, what it helps us with this lag, we as I said, severely under-earn our authorized return today. This bill helps that be a little bit better, but there is a guarantee in the committee substitute that we cannot earn more than the PUC authorizes to, and if so, that gets rebated back to customers.
Who else has Encore talked to about this bill?
We've had a very constructive set of discussions with Texoga and TAM, and again, some of what is in the committee substitute reflects that, most notably this, we sort of call it the shot clock and getting the Permian transmission built. We have talked with the PUC staff and PUC chairman about the mechanism and again, how we think it helps with their workload. We've had great discussions with OPUC, the Office of Public Utility Council, and have talked to other potentially eligible utilities. We've talked to retail electric providers, and we have communicated with the cities and offered to talk to them. We have not heard the specific complaints or issues they have with the bill before today.
Does this bill limit the utilities only to the Permian Basin?
The way the bill is structured, yes. And again, we have focused it from following your bill last session, Chairman Guerin, House Bill 5066, where the state has now done this very extensive planning process for the Permian. And we will have around $14 billion or more that we will be required to do to execute that plan, again, by 2030. That's great for the state. It's great for the national economy as well. As Ms. McQueen laid out, we're doing this on top of this other massive capital plan that we have today, and we know the rating agencies have done this math on us, some of the other Permian utilities like AEP and are challenged in the same way we are. So in order to help us fund this investment and build this transmission timely, that's why we bracketed this concern to the Permian building utilities. There may be other utilities with other pressures, and I can't speak to those, but this is what we focused on here. And I do want to make that point again, that we've agreed to accelerate the Permian build out to 2030. That's a stretch for us, and there's a penalty that we will receive in not getting some of the benefit of this mechanism if we can't hit those deadlines, and it's our fault.
Do you think this bill needs a sunset provision?
You know, the way the bill is structured, where you have to continue to invest 300% of your annual depreciation, it somewhat works itself out over time, because as this growth cycle ends and as our depreciation grows, it becomes harder and harder every year to meet the mechanism. So we didn't include a sunset in the bill. We have heard from the Office of Public Utility Council and some others that perhaps a 2035 sunset. We don't have an objection to that if folks are interested in putting it in through the process.
Well, So you wouldn't have any objection if I visited with the PUC and we put a 2035 or later sunset date in?
No,
this?
sir.
Thank you, sir, and thank you for being here
Yes, sir.
today.
Any other questions? All right, thank you.
Thank you.
All right. We have a resource witness, Anna Givens. We have you registered as Anna Givens on behalf of the Public Utility Commission of Texas as a resource witness on House Bill 5247.
That's correct. Good evening, Vice Chair Hernandez, members of the committee. My name's Anna Givens, and I'm Director of Financial Review within the Rate Regulation Division at the Public Utility Commission of Texas. And I'm here this evening to answer any questions and serve as a resource witness.
Thank you. Representative Davis?
Thank you, Vice Chair Hernandez. I had a couple of questions as it relates to this study that you did to come up with this plan. It says that you all had PUC put this plan together for the Permian Basin. I was tasked with that last session to come up with a plan to address the needs for Permian Basin area. Is that not correct?
So I'm not prepared to answer that question. I'm here to answer questions regarding this rate recovery mechanism, but I have not been involved with the study for the Permian Basin.
It says last session, and if I'm wrong, tell me. Last session, the legislature directed the PUC and ERCOT to develop a Permian Basin reliability plan to ensure the needed grid capacity. And you approved a plan for $12 billion. Were you not aware of that?
So our commission has, but that plan was not within the specifics of the division in which I'm employed.
Okay. So my questions are relative to what you did in terms of developing this plan. So you aren't able to answer those questions?
No, ma'am.
Okay. Thank you.
Any other questions?
Get somebody here next.
Thank you. Katie Coleman? We have you registered as Katie Coleman on behalf of the Texas Association of Manufacturers, testifying for House Bill 5247.
Yes, that's correct.
You may proceed.
Thank you. Katie Coleman, Texas Association of Manufacturers, and we are testifying in support of this bill. Y'all know that I am not usually in the business of giving utilities more money faster. This is, in our estimation, a very, very unique set of circumstances that some of the companies that are responsible for the Permian build-out and other extreme load growth areas are facing financially. We have had our consultants who look at financial metrics and credit for us in rate cases, look at the situation these utilities are facing, and we do believe that some extraordinary treatment is warranted in this particular set of circumstances. The reason that we like this bill is that it is a better alternative in our mind to more aggressive and potentially more broadly precedential measures like giving the utilities a higher return on equity, a more advantageous capital structure. Those things can be considered in rate cases, but this is a very targeted approach that really just applies while these utilities are experiencing the extreme growth, and when that scenario subsides, it goes away. And so that's why we're supporting it. And I do want to say that the bracket that is in there is very, very important to us. Our position would be very different on the bill if this were universal and applied in perpetuity. But with the bracket, we think it is a very targeted and tailored solution, and we do support it. Some of the customer protections that are in the bill that are very important to us, we've been negotiating those with Chairman Guerin's office and the utilities that are requesting this bill. I think the over-earning protection is very important, the load growth revenue protection, and the sunset date, I think we are also interested in potentially adding. So we do, at the end of the day, think this is a very balanced bill, and we are supportive.
Any questions? Chairman Guerin?
Katie, would y'all support a sunset in this bill?
Yes, we would be fine with that.
And do you believe that this will help the utilities and their, protect their credit rating?
Our consultants who specialize in that have looked at these issues, and the credit ratings are really driven by cash flow to debt. And what this will do, it doesn't allow the utilities to begin recovering on day one of the investment. They still have to come in and get the commission to approve it, but they get to carry forward that balance. And the ratings agencies will look at that, and they know that they're going to collect that balance. And as those cash flows start coming in when these proceedings are filed, we believe that it will support the credit ratings of the affected utilities, and that it will actually be a lower cost and more targeted solution than other measures.
I want to thank y'all for working with us on this bill. I think it's really important, but y'all have been very cooperative and really good input, and I want to thank you for that. Thank you, Madam Chair.
Any other questions? Thank you. Chair calls Jason Ryan. We have you registered as Jason Ryan on behalf of CenterPoint Energy Neutral on House Bill 5247.
That's correct.
You may proceed.
Thank you, Chair Hernandez, and thank you to Chairman Guerin for starting this conversation on this important bill, and we look forward to continue to working with you and stakeholders on it. I thought I'd make 2 points this evening. First, that we believe that this bill has good underlying policy, and I'll go into a little bit more detail on that. And we think that that good policy should apply to all of the similarly situated transmission and distribution utilities in ERCOT. As written, I believe this applies to 3 of the 4 TDUs. It just excludes Houston, and we think that that could have some unintended negative consequences, so I'll talk a little bit about that. First, as to the good policy, this is probably the most important change in utility rate making since Dean Thompson passed a bill in 2011 that dealt with distribution capital. And that bill came at a pivotal time of growth. We in Houston had just surpassed 2 million homes and businesses that we serve, and we had just started to double our annual capital investments to serve those customers from $500 million a year to over $1 billion a year. And in the time since that mechanism has been in place, we've been able to fund the growth at that elevated level and keeps rates relatively flat over that period of time. In 2020, we got to the point where we were more than doubling again the infrastructure that we were investing in Houston. And as we close in on serving almost 3 million homes and businesses now, up from 2, we are spending nearly $3 billion a year instead of 1. And so we think it's the right time to have this discussion on this policy. Second, as it relates to utilities that this is applicable to, we meet the qualifications in the bill, other than we're not building transmission in the Permian. We're not building in that location, but we're building because of the activity in the Permian. Hydrocarbons go southeast to the largest petrochemical complex in the world. So happy to answer any questions.
Any questions? Thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 5247? If not, the chair recognizes Chairman Guerin to close on House Bill 5247.
Thank you, Madam Chair. Thank you, Mr. McQueenie. And I close, unless there's a question.
Other questions?
Ms. Davis.
Representative Davis.
So Mr. Prepay has explained to me that this is the way we do this here, but I had a question with how we got here. I want to understand the agency's role and stuff, so you may have background that happened prior to this session, and I'd like to visit with you about that.
Yes, ma'am. I actually passed the Permian Study Bill last session, and actually the word study is not in the bill from last session, although the PUC and ERCOT somehow decided that it must have been in there.
Well,
and so we've done a lot of studying, but this bill came about partially because of that, but more so because of the threat of the credit ratings going down and this costing a heck of a lot more than it will if they can maintain their credit ratings. And the agency has been consulted on all of this, and they have really expressed no concerns with this procedure.
And I don't question what you're telling me, I just want to understand the agency's process. What I have question about is what all was looked at in terms of, I appreciate and have been meeting with the industry, talking about their challenges. I want to understand that the agency looked at challenges from other perspectives as they contemplated this. How do we get the 12 billion? And they're talking about now even needing more. So I just want to understand that process, and I'll get somebody to come by the office and visit with you.
Yes, ma'am, and I'll be more than happy to attend that meeting if you'd like.
Perfect. Sounds good. Thank you.
Any other questions?
I close.
Thank you. The committee substitute is withdrawn. If there's no objection, House Bill 5247 will be left pending. Is there objection? The chair hears none. House Bill 5247 is left pending.
Chair lays out House Bill 3439, recognizes Chairman Guillen to explain the bill.
Thank you, Mr. Chairman. Members, this is a targeted update that strengthens the investigative capabilities at the AG's Criminal Investigations Division. This division handles high-priority cases like recovering missing children, locating fugitives and sex offenders, and dismantling human trafficking operations, often in remote or resource-limited parts of the state. Under current law, they're not recognized as a designated law enforcement agency under Article 18B of the Code of Criminal Procedure, which creates unnecessary delays when applying for judicial orders to use electronic tracking tools. These delays can make a difference in time-sensitive investigations, especially when a district attorney who currently has to sign off on the use of these tools is unavailable, or when coordination with a currently designated agency proves difficult or impractical. This bill addresses this by adding the AG's Criminal Investigations Division to the list of entities authorized to use tracking equipment and issue administrative subpoenas, joining major municipal police departments as well as the Inspector Generals of the TDCJ and TJJD. The bill doesn't expand investigative powers under Article 18B. Existing oversight remains in place as their office will still be required to present legal process to a district attorney's office for their review and approval. It also ensures transparency through required notification to DPS when subpoenas are issued. This gives the AG's office the same tools already available to other major agencies so they can move faster and more effectively in serious criminal investigations. Happy to answer any questions.
Members, there are questions for Representative Guillen. Oh, Mr. Turner has one.
Thank you, Mr. Chairman. Thank you, Chairman Guillen. I was trying to understand, is there been a problem that has been identified where the Office of the Attorney General didn't have this ability that they needed to have? Because I'm just thinking about all the, obviously, numerous local law enforcement agencies across the state, plus DPS, plus obviously federal partners like FBI, DEA. I mean, they have, a lot of power in this regard. And I'm just wondering if there's some hole in law enforcement that's been identified that this bill is trying to solve. Is a lot of power to get.
They should be here
AG.
To answer that question. This is something I filed at least one other session, maybe two.
Is that right? Okay.
And so, but I think they're here as resource witnesses that can answer that question.
Okay.
Yep.
Thank you.
Members, any other questions of Representative Guillen? Mr. Turner, would you like the resource witness to come forward? Do I have one? Okay, who do we have? Chair calls Rustin Habby. Now, how do you say your last name?
Havey.
Havey, okay.
H-A-B-Y, Havey, like
All
baby.
right. Rustin Havey.
Yes,
We
sir.
show you registered on behalf of the Office of the Attorney General. You're neutral on the bill, is that correct?
Yes, sir.
And you're here as a resource?
I am.
All right. Mr. Turner has a question.
Thank you, Mr. Chairman. Thanks for being here. You heard my conversation. I'm just wondering why the bill is needed.
Oftentimes, sorry, I feel like I'm yelling in the mic. We work with a lot of small agencies across the state, and sometimes the bigger agencies like the United States Marshal Service or DPS are not available to help us with any kind of, them being a designated law enforcement agency. And we would have to go to the assistant district, or the district attorney themselves. And sometimes they have many different areas they cover and they're not available. With this, us being added to this bill, we would be able to go to the assistant district attorney. We currently have the power to go apply for these orders as it is right now. This just makes it a little bit easier and a little bit swifter for us to bring people that may be threatening victims or any kind of future victims that they're looking for. As Representative Gillian had said, there's multiple different people we look for, and we go after. Their violent criminals, child predators, human trafficking suspects, missing children that may be endangered. The quicker we can get that suspect off the street or away from any kind of victims or prevent any kind of future victims, minutes is the game for us. So we try to do it as swiftly as possible.
Yeah, and I think we all support the goal of getting, offenders like that off the streets as soon as possible. I just wondering if there's a gap with respect to local law enforcement and then DPS and then federal agencies that the OAG is filling in this regard, that you need this additional tool. That's what
We
I'm
help a
just
lot of
struggling
small
with.
agencies. My guys in my units, I really try to push them forward to help small agencies that don't have the resources or the bandwidth to go outside of where they work to look for these violent criminals or what have you. So
Is DPS or others not available to help them?
they are there, but oftentimes there's a reluctancy to help on smaller counties because they're so busy in the bigger municipalities and what have you. So we would be able to fill that gap to help out these small agencies. And a lot of times these small agencies don't have the ability or the knowledge to do this. And they would rely on us to move forward with it.
How big is the law enforcement division of the OAG?
I believe we have 113. I'm not 100% sure on the total number right now.
They're around a little over 100?
Yes, sir.
Is that about right? Okay. So I don't know how many troopers DPS has right now, but I know it's a lot more than that. So that's why I'm just trying to understand
well,
how
I can see
they wouldn't be able to help.
So it's not
small
necessarily
agencies, but y'all
think there's
can
a-
at a much smaller size.
I think there's a list of people that are that are given to the department, the DPS, where we're allowed to, we'll tell them, these are the people that we're gonna be doing these type of cell site simulators and pen registers and trap and traces. So not everybody in DPS, the local trooper may not necessarily have the skills or the knowledge to do it, where you may have to rely on their criminal investigations that they have, or their rangers or whatnot.
Right, yeah,
Which is
they-
a lot smaller than just the whole.
Of course,
DPS as a whole.
Yeah.
Yes,
So is everyone in the OAG's division a criminal investigator? I mean, at that
Yes.
level of
Well,
credentials?
sergeant, we hire sergeant and above, we hire with experience, so, yes, sir.
Okay. But you said right now you can do it, you have to, what's the process now? You go to a judge to get a
So
order?
the process would be, we develop the number, okay, on a suspect. We verify that number with multiple different sources until we make sure of the freshness and the legitimacy of the number. And then we will take.
You say a number, like a phone number?
I'm sorry, a phone number, yes, sir.
Okay, all right.
Because we're tracking ultimately a phone to find
Right.
who we're looking for. We would put the order we would get with the district attorney, because right now we're not a designated law enforcement agency. So we would have to get with the district attorney themselves to actually get them to help with the order. Whereas the only simple change would be if we're added to this Title I 18B, we would be able to use the assistant district attorney. That's all that really changes.
Okay. All right, thank you.
Yes, sir.
Ms. Thompson. I think the laws that you are enforcing are state laws, is that correct?
Yes, ma'am.
And that falls within the district attorney or either the county attorney.
Yes, ma'am.
And the attorney general is in the executive branch of government. So there's a conflict here. This bill attempts to give powers to an executive that belongs to another branch called the judiciary branch, which county government, like the county attorney and the district attorney are members of. The Constitution of Texas clearly states the delineation of these powers, and the attorney general has no criminal powers, and the state just can't give this to them without changing the Constitution of Texas.
Okay.
Thank you.
Members, further questions? Mr. Anchia.
Thank you. I guess I'm today years old, realizing that the OAG has a police department.
A lot of people don't know.
How long have y'all had this?
So there's multiple different units that we have. My units are child exploitation, fugitive apprehension, and digital forensics and sexual extortion, which we do investigate criminal charges in the state of Texas.
I mean, how long has
we
the
started
Attorney General's office had people in uniform like you?
We've started the fugitive apprehension started in 2003. And it's about the same time it started out as the Cyber Crimes Information Bureau or something, which ended up being the child exploitation unit.
Is everybody in your units, or in all of the units, a peace officer?
Yes, sir.
Okay.
They're a sergeant investigator.
You're all sergeant, but everybody does T-Cole, and you're all peace officers? And
Absolutely. We're
okay.
all abide by the same rules as DPS, OIG,
Got
the
it.
county sheriffs, everybody that's on the designated list.
Got it. And the gap here is that other law enforcement agencies, you're not currently included in the statute in 18B 001, right? And you're unable to do what? Because you're not in the statute.
It's not that we're unable to. We would be able to bring the, sorry. Can you hear me now? It's not that we wouldn't be able to. This would allow us to be more expedient and bring these guys to justice or get them away from victims. For example, and I have a case that we worked, he's a child exploitation case. He was a doctor. And we served a search warrant on the guy. And he had multiple images of child pornography.
Mm-hmm.
We indicted him for 11 counts of it, and that was in 2002. In 2003, he was convicted, and in 2004, in Bexar County, he was supposed to be sent for sentencing. This guy had access to kids at the Children's Hospital in San Antonio. He was a regional director in LaSalle County for children.
Mm-hmm.
That he was responsible for the medical director job down there, and a couple others. They served search warrants, found all his pornography. 2024 comes around. He's supposed to go before Bexar County and be sentenced to whatever he's going to be sentenced to. Well, he didn't show up.
For those crimes back in 2003?
No, 2022.
Okay.
He was
okay.
indicted in
I thought you
2022.
said 2002, and I was trying to
I may have
reconcile the lag.
I
in
may have
time.
misspoke.
I got you. Okay.
So-
and I'm just trying to follow the timeline. 2022, 2024 rolls around.
And I
He
promise
disappears.
it has validity when I get to it.
Okay.
In 24, he's going to get punished, right, in front of the jury, in front of the judge, and he's gone. He doesn't show up. So our child exploitation unit got with our guys on the fugitive apprehension unit, and he was able to find out that he had bought a mobile home, and he drove all the way down to Belize, and we tracked him by phone to where he was at down in Belize, and he was, I don't know what kind of victims he had down there because these guys don't stop. Right. And we were able to bring him to justice quickly.
Okay, so that sounds like a successful interdiction, right? You tracked him, you found him. What does this bill do differently that you weren't able to do in that fact pattern?
The simple thing it does differently is allows us to more quickly get the orders and get the process rolling and started to apprehend the suspects and bring them to justice quicker.
And how would this have changed that, the fact pattern that you laid out? Would you have
So-
stopped him from getting to Belize? Did you know he was down there? It sounds like you.
They didn't know he was down there at all.
You didn't know, nobody knew he was down there?
Through that investigation, they figured out that he was down there and out
Okay.
of the country.
So what about the speed of getting that order would have changed the outcome of that fact pattern?
So my investigator at the time, he's not on the, as a designated law enforcement officer. He happens to know the DA that he used.
Okay.
And luckily, she was
Helpful.
she was there because she was in Washington DC. And she was there for one day and he happened to catch her on the one day.
Okay.
If not, we would have had to wait till she came back or convince one of the designated law enforcement agencies to help us to get the order written, to get everything.
So let's say she had not been there. Where would you have gone next? DPS, probably?
This particular guy that I'm speaking of, my investigator,
Yeah.
he's on the Marshal Service Task Force. Because we have guys on the Marshal Service Violent
Okay.
Offender Task Force. And he would have tried to use DPS or OIG if they're available.
Okay.
But they also have their own cases they work too, so they have a lot of stuff going on as well. So-
Okay, thank you.
Members, further questions of our witness? Seeing none? Thank you for being here.
Yes, sir.
All right. Is there anyone else wish to testify on, for, or against House Bill 3439? Seeing none, Chair recognizes Chairman Ginn to close.
I close. Thank you, Mr. Chairman.
If there's no objection, House Bill 3439 will be left pending. Is there objection? Chair hears none. House Bill 3439 is left pending. Members, that concludes today's agenda. Is there further business before the committee? If not, Chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned. Subject call to the chair.